Committee in Whole is now called to order. It is now 1:40 on July 3rd, Wednesday. So before we begin, I would like to provide you with the agenda for today. So we will start off with each of the panel members presenting. We will start off with each of the panel members presenting on information that I've asked them to provide, and then followed by a panel of question and answers. We'll have different rounds. Each senator will be limited to about 5 minutes of questioning. The answers can extend beyond the 5 minutes. Then we will resume rounds to make sure we exhaust all questions. The purpose of this committee in whole is to basically explain to our body the urgency of the matter to address Bill 2 from the governor, and to see if the urgency is great enough to waive a public hearing. So we're going to start off with bringing in the invitees to be sworn. Have they been sworn? Okay, so only those that were invited are allowed to be here. Everybody else, I would have to ask you to leave. So only the people that were invited and a staff member. If you are not of that agency, I'm going to have to ask you to leave. Okay, before we start, I would like to ask each of you to introduce yourself and your position and what agency that you are from. We can start with my far right, Dr. Denton. Oh, sorry, the far right. Wait, sorry. Here. The far right. Who's that woman?
Good afternoon, ladies and gentlemen, the senators. My name is Gary Denton. I'm retired, but I'm here to represent Water and Environmental Research Institute, University of Guam.
Miguel Bordallo, General Manager of the Guam Waterworks Authority.
Carmen C. and Denton, retired from Guam.
Madam Chair, can they have them speak louder into the mic so we can hear where they're from and who they are?
I'm Carmen C. Denton, retired from Guam Waterworks Laboratory.
Walter S. Leongaro, Administrator, Guam EPA.
Oh,
Good afternoon, everyone. Daniel Stone, Fire Chief, Guam Fire Department.
sorry, can you hear me now? My name is Gary Denton, and I'm with the Water and Environmental Research Institute, WERI, at the University of Guam.
Thank you, Dr. Denton.
Levin Camacho, Office of the Attorney General.
I'm Ken Orcutt. I'm the Deputy of the Litigation Division of the Office of the Attorney General of Guam.
Fred Nishihira, Deputy Attorney General's Office of Guam.
Paul Packbeer, President PCR Environmental and Environmental Consultant to the Guam Airport Authority.
Ray Santos, Assistant Chief, Guam International Airport Authority Aircraft Rescue and Firefighting.
Ray Mantononia, Fire Chief, Guam International Airport Authority Firefighting. Good afternoon.
Okay, thank you all for being here on short notice. I would like to start off with Attorney General's office to explain the questions that I put before them. So I actually, to kind of give you a context, before I asked the agencies to come in, there were a couple of questions that I asked them to prepare for. So one of the questions is, what do the agencies know about PFAS, and if there's evidence of contamination to date? What actions are being pursued? What is the effect of PFAS on the public's health? How was it brought to Guam, and what are its uses and who used it? How urgent is it that it be addressed? For the AG's office, I added that they explain the urgency of this matter and to explain the multi-district process. So I would like to start off with the AG's presentation.
Point of order, Madam Chair.
Yes, Senator Nelson.
The motion was made to come to Committee of the Whole with the understanding that we would be given information and documentation referring to PFAS. And so I'd like to thank the Guam Fire Department for providing their documentation, but we have not received documentation from the other agencies, which is why we waited till 1:30 to give them an opportunity to gather the information that we request. Because of the urgency of the matter, I'm sure there's documentation proving that this PFAS chemical is in existence, and perhaps we could get the documentation before we move forward.
Okay, so yes, I did not bring that to their attention. In order to do that, we probably would have to recess for them to get that documentation.
Well, then perhaps we can move forward, but I'm sure that it seems like they brought their teams here, so maybe their teams can work on gathering this information before we leave here today. I think that's very relevant if we're foregoing a public hearing. To examine the urgency of the matter, we need substantial documentation to support this so that it can be on record. Excuse me.
Thank you, Vice Speaker. So yes, if I can follow up with that request from all the agencies here, if they can provide the documentation as soon as possible, they can present that.
If I could just ask for the copy of the papers from the Guam Fire Department? I don't think they were passed out here.
Yes, Senator Lee.
Suzus Masi, Madam Chair. It's also my understanding that perhaps the Office of the Attorney General does have written testimony that might be passed out. It's addressed to the Speaker and the members.
We did submit a written letter or testimony that was sent to all of your emails. I only have 2 printed copies, but if you have staff that are here, they could probably print it out. Okay.
Yes, let's take a brief recess.
Hit your gavel.
So there's a question about whether you have written testimonies for the governor's bill. No. Yeah.
Point of order, Madam Chair. Are we back from recess? I believe we're still on recess.
Committee on Whole is resumed. So just to reinitiate or reinforce the rules of engagement, each senator will be given 5 minutes of questioning. That does not include the amount of time that's given to answer. We will go through several rounds depending on the how much questions are posed. Again, the purpose of this Committee of Whole is a case that the AG has to make of whether how urgent this matter is to forego a public hearing. And so we would like to start with some questions, starting from the first on the list would be, excuse me? And we have other agencies here too to provide information as far as evidence of PFAS contamination, as well as the urgency of dealing with cleanup. Yes, Speaker.
Madam Chair, if I may, so based on what was just initiated earlier, are you going to ask the panel members to give their presentation based on the inquiry that you asked each and every one of them before each senator has a round of questioning? Or are you just going to go to the answering the question and answer period now?
Thank you, Speaker. Yes, to clarify, since the questions were not received by the different invitees here, we're just going to proceed with the question and answers. So we're going to go right into the Q&A regarding in addressing the urgency of this matter to forego a public hearing.
So if I may, just to start off, Madam Chair, I'd like to ask the Office of the Attorney General of Guam, because he's got a written testimony prepared, if he can share with that, and then I would see if I can ask the panel other questions.
Yes, that is a fair request. I will grant that. Thank you. So we will proceed with the Attorney General's office providing their testimony, and then we'll follow with the question and answers.
So just to clarify, you would like me to read the written testimony submitted?
If you have a prepared statement, I would allow you to read that and then open it for the question and answer period.
Yes, Speaker. As stated in my letter of June 28th to the Governor, I support the passage of the Pratehi v. Hanam Act of 2019. My office will be pursuing legal claims for damage to Guam's water from the use of, I'm not a scientist, so I cannot pronounce that, PFAS. We will take the lead in this litigation, but recognize that a suit of this type will require the use of a consultants and additional counsel to put forward the strongest case for Guam. This bill would give our office the resources to best navigate a case that will involve hyper-technical scientific analysis and the assistance of attorneys who specialize in environmental litigation and multi-party litigation. The exact cost of this litigation is unknown. If the government of Guam were to pay upfront for consultants and legal services, it is expected that costs would quickly reach hundreds of thousands of dollars just for the initial phases of research, filing, and discovery. We will be transparent about any agreements with experts. If the legislature passes this bill, we would engage in quick and well-documented process of comparing the fees, experience, and availability of firms willing to assist Guam. The AG's office is the chief legal representative for the government of Guam, and it is also a steward of public funds. To be clear, law firms have expressed interest in representing Guam, but our office has not received or solicited any formal proposals, discussed any specifics regarding representation, or committed to selecting any law firm. To get the best possible representation and the best fee structure, even with the authority afforded by this bill, it will take several weeks to compare and engage expert services, research the claims available, identify all responsible parties, and finalize a complaint. If the legislature does not pass this bill, my office could put together a preliminary complaint. Although we one day hope to have the internal resources to file cases like this, we do not currently have the expertise or funds that would be available to a law firm or consultant that specializes in these types of cases. Without immediate action, we could then ask the legislature for an appropriation so that we could use the existing procurement process to acquire legal or other expert services. This method is less than ideal, and it could jeopardize our ability to represent the government in the best way possible. As the legislature is aware, we have requested urgent action because current multi-district litigation related to PFAS contamination is proceeding quickly. The existing procurement process may mean we miss an opportunity to be heard in a forum that is already familiar with these types of cases. It could also limit our ability to seek relief against all parties responsible for the harm caused to Guam's water. Filing a claim against private parties would not preclude subsequent action against any government entity where damages warrant legal action. Using a firm that has previously participated in environmental contamination suits means that Guam would not have to start at step one. Its prior experience can provide knowledge of potential defendants, required measures to prove contamination, possible methods of payment or remediation, and other useful information. The use of a contingency fee arrangement presents an opportunity for Guam to engage in large-scale litigation related to damage to our environment without first having the money to acquire the expertise necessary to competently pursue these claims. With regard to keeping the governor, legislature, and public notified of the progress in this litigation, I fully support the concept that the status of litigation should be reported by our office. Such status would and should be public information. In particular, if during a case we uncover information that there is new and significant danger to our water or our people, we should report it. However, I note that reporting on the status or cost of litigation is very different from reporting on litigation strategy or communication between our office and our consultants. The privilege to protect the confidentiality between an attorney and client is long and deep-rooted for a reason. A client and attorney need to speak freely without worry that information relevant to legal strategy may be revealed to opposing parties and damage their case. Our community, including several members of the legislature, has been calling for action to address this issue for years. Every day that passes is a day that we could be working to secure the best firm available at the best rate to file the best case for Guam. We are ready to proceed. Thank you.
Thank you, Attorney General Levin Camacho. So we're going to open up the floor to questions. We're going to start with with Senator Bisco-Lee, if she has any questions to our panel here today. Wait, okay. Vice Speaker Nelson.
Just to be clear, Madam Chair, are you doing this in alphabetical order? You're calling us?
Oh, I don't have the roll, so I'm just going by from rear to front.
Okay,
Yeah.
sure. Thank you, Attorney General Camacho, for your letter. However, Madam Chair, this does not specify the cause for an emergency. It specifies that it is an endeavor that we'd like to move forward with, but not the cause for an emergency where we forgo a public hearing. Inconvenience is very different from emergency. And so perhaps we can talk to Guam Waterworks Authority. A question for them is, are they currently testing for PFAS in our water wells? And if so, what is the amount of PFAS that they have been detecting since 2015?
Thank you, Senator Nelson. The answer to your question, yes, we are currently testing for PFAS in our water wells. Maybe to provide some background, we've been sampling since 2015, which initiated our sampling because of the UCMR program with the US EPA. At that time, PFAS was identified as a constituent in some of our raw water wells. And since that time, we have been monitoring the wells which showed detections. And subsequent to that UCMR program, US EPA lowered the health advisory level in 2016. And since 2016, for the impacted wells, we've been monitoring quarterly. The levels of PFAS in the water supply have ranged from in the 20s parts per trillion to the hundreds of parts per trillion in various wells, and they've fluctuated over time. So the latest round of information we have for the wells that are currently operating, and right now there's only one well operating, that's NAS1. That has a treatment system in place, and so we have detected about 50 parts per trillion in the raw water, And after the treatment system, we have no detection of any PFAS entering the distribution system.
Thank you, Mr. Berdalio. The 50 parts per trillion in the raw water is filtered through a carbon system, and then you test it on that end, and you don't detect any PFAS on that end where the water is being consumed by the people of Guam, wherever that NAS-1 well leads?
That is correct. The raw water coming out of the well has 50 parts per trillion as of our last sampling, and the treated water after the carbon filters has non-detectable levels. So I think the method detection level is about 2 or 3 parts per trillion, so it's below that.
Is there any way that we can identify PFAS being collected within the wastewater system? And perhaps when the wastewater goes to the treatment plant, we can detect the existence of PFAS or the prevalence of PFAS at that end to see how much is being dumped into our waters?
I don't know the answer to that question, Senator. I know that the testing may be possible, but I don't know the answer to the question.
So I guess that brings me to my next question. Does GWA perform this testing for PFAS that is being funneled through our wastewater system? Or is there another agency that would conduct it on GWA?
We are not testing any wastewater effluent. So the only place we would test it is in the clear treated effluent that before it exits into the ocean outfalls. We have not conducted any testing for PFAS on the wastewater side.
So at this time, the wells that fill our sinks that we drink from or that are being filtered, that the water that we drink from, PFAS is not detectable?
That is correct. The water that we distribute in our distribution system does not have any PFAS in it.
In any of our wells that the community, the people of Guam drink, PFAS is not detectable?
No, the well water, it is detectable. As I mentioned, NAS-1, there are detectable levels and we have it, but we treat it before it goes into the distribution system. So the treatment systems that we are operating are effectively removing it from the raw water before it is placed into the distribution system for consumption.
So I can consume a glass of water and there's no PFAS detected in that water? Straight from the tap?
Absolutely.
Okay. Madam Chair, I do have some other questions, but I'm waiting for additional documentation. There was a letter saying that there were preliminary findings, which is why this PFAS is an urgent matter. And so I'm just wondering what the preliminary findings are. So I will hold, if I can hold the rest of my question time at a later date, at a later period during this committee of the whole.
Thank you, Vice Speaker. So just in the interest of saving time, I'm going to go through the questions that I should have been sent out to all the agencies here. And if you can respond to those questions. So starting with the AG's office, can you explain the urgency to address this bill today rather than have a public hearing on Tuesday?
And this is where I think our office and the other participants differ a little bit. You know, we're lawyers, and we look at what claims you can file, and you want to protect all possible claims against all possible defendants. And I know Vice Speaker had mentioned inconvenience. Well, if you miss a deadline, you could be barred from filing a claim. There are also time deadlines that are imposed by courts. We've mentioned the multi-state litigation, the multi-district litigation that is moving forward, and they are prioritizing state sovereigns in particular. So I would say that it's not only an inconvenience, but it could jeopardize the thoroughness of the complaint that is filed, and even if we are able to participate in these cases. So I can't tell the legislature you have to file. If you would rather jeopardize the ability for Guam to put forward its best case, that's up to you all. That's the responsibility that you have. I can
Madam
only
Chair,
advise
point
you.
of personal privilege. The Attorney General is here to give facts and findings and preliminary information to why this is urgent. He's not here to question what is a priority for the legislature. I am sure that this issue is a very big priority for all of us.
Yes, if you can stick to the facts as to why waiving a public hearing, which is scheduled for Tuesday, is necessary, and in order to address the bill today. I wish you could stick to the facts as far as deadlines, and maybe speak to the process of this multi-district process that you are pursuing or interested in pursuing.
Again, there's going to take time to reach out to firms, to get proposals, to evaluate those proposals, to finalize an agreement, to now conduct the research that would be necessary to file a claim. And this is not something that you can just wake up one day, roll out of bed, and draft a complaint. This is going to take some time. So for lawyers, one day of drafting and reviewing a complaint is a huge amount of time for us. One day of procurement, we're looking to compress basically procurement outside of procurement in a possibly 4 to 6 week deadline. We've mentioned that there's an August 4th deadline in the multi-district litigation to add new parties to cases. And our office has been in communication with other state attorneys general. They have had to amend their complaints several times to include proper defendants. We could possibly lose out on an opportunity to file a claim against defendants if we don't get it right the first time. So I'm not here to make a decision. Again, if that's a risk that the legislature would like to take and wait for a few more days, that's fine. But we are here to present. There are deadlines. This is an urgent matter. We know PFAS is in our water. We know that the government of Guam currently is paying out of its own pocket to remediate without contributions from the people who put the PFAS in the water.
Okay,
and whether
yes,
or not
you did cover that in your testimony. We just want to stick to the urgency of the matter.
If I may, so I represent the Consumer Protection Division, and I'm the one that has been in contact with other states, including states that are in litigation, not using private counsel. They are part of this multi-district litigation, and in consultation with them, even though they are not using private counsel, what they are doing as a result of being part of the multi-state litigation is they are using other states who have private counsel do the heavy lifting. In other words, in the multi-state district litigation, you already have an executive committee that is heading up the discovery, that is putting together the experts that are doing all this work. So they're very far ahead in the game. The reason why the state that I've been speaking with is New York. They're similar to us. The reason why that they are choosing to do this is because they realize that private counsel has a bigger interest in doing this because they are also proceeding on a contingency fee. In other words, if they don't win, they don't get paid. So the private counsel within themselves are boxing each other out, trying to stake a claim, knowing that whoever does the most work as private counsel will get the most paid. So the urgency that we are looking at is we have an August 4th known deadline to us to possibly join this multi-state litigation. When I say we, our office has never engaged in this type of litigation. So New York State, the people I've been talking with, they have an environmental bureau within the Attorney General's office. 4 of their attorneys, not including their deputy, is doing and overseeing this case. And even they, with that type of resources, are looking at private counsel to take the lead. And so what happens in this particular case is, the way this case, a little bit background just so you know, the way the multi-state district litigation occurred is you have basically 3 different type of plaintiffs. You have individuals who have sicknesses and ailments caused by this product. You have private water providers that sell water and are plaintiffs. And then you have states and state entities, cities and counties. And so what's happened was the defendants actually said, look, these claims are all similar, can you join them together? The court looked at it and said, yes, we agree it should be put together. That happened in December. What happened since then, now remember, every one of us has been involved in litigation. It's a very long, drawn-out process. Except in this case, this judge has been moving very quickly. And so this judge has, in addition to putting the panel together, they are right now considering, and it looks like it's going to happen, they are going to categorize the priority of these plaintiffs. And what they are doing is, number one, the plaintiff that's going to go first are going to be the cities and states. And the reason why is causation, right? Basically connecting the dots. If the state can't prove the case, then it's much harder for the individual to prove the case because they have more dots to connect. In other words, the individual might say, well, because I'm also a smoker, family history and so forth. So they're looking like they're going to put the states first, which might mean or might explain why the judge said, you have this August 4th deadline to join in. If you don't join in, then you're going to miss the boat, basically. So that came out in, I want to say, June. So really, I appreciate all the water.
Is that June of this year?
Yes, June of this year. Remember, the multi-state wasn't even put together till December. And so this December 2018, right? But I mean, basically it's 6-7 months. And that's incredibly quick for any litigation. And so the urgency didn't come about because of the chemical in the water. We know it's here. We know that the product is harmful. We know GWA is doing mitigation and so forth. But what we didn't know was that litigation would speed along as fast as it is going. So what we see right now is the one opportunity that we can jump on and use the resources that even other states who do not have private counsel take that opportunity and use it to our advantage. Really, we don't have the resources, even if you gave us the money, even if you let us hire the professionals, we just do not have the resources and ability. And quite honestly, really, for such an important matter, do you want to have somebody basically like me taking up a case like this? I mean, really, you don't. People do their livelihood in this area. So the urgency, senators, of the reason why this bill needs to pass, or we recommended passage, is because we want to take the advantage of the opportunity to get these experts on board, let them do the heavy lifting, and let us benefit as a result. I've listened in and I've heard other questions about remedies and well, do we have a say-so in the end result? And the question is, when you're involved with the multi-state litigation, there are very many factors that are involved. And basically, the judge is the one who makes the final decision, because every single one of the plaintiffs are going to be saying, no, I should have the lion's share. Well, I think you could do this better. So it's basically a formula in how it's adjusted and say, in the end, here's what you get. So that's kind of how it works when you join in a multi-state litigation. And of course, maybe the final thing I'll end with is, if we don't join in now and this multi-state goes first, remember, we're going to be after however many plaintiffs. I want to say it's in the hundreds of plaintiffs right now, might be more than that, might be in the thousands. We come in line after that. So one of the first things I said was, right now it's looking like not only are we going to be in the top tier plaintiffs in the multi-state litigation, being a state, if we don't do this and we file our own case, we will be maybe number 1,001 in line. There are things like bankruptcy we need to consider, and well, I won't get into those details, but that's basically the bottom line of the urgency. So when the litigation started speeding ahead and it's going faster and faster, we approach the AG and say, you know what, this is a matter that we need help, because we had looked at procurement, and the bottom line is, if we RFP and go through the procurement, we would first need money. So we have not engaged in discussions with any of the firms. We actually will have a process in which how we evaluate the criteria of the firms we've selected. But that's the bottom line. That's the urgency that we see.
Okay, so we have questions, follow-up questions. Sure, we're going to go in order. So we kind of broke for the presentation. So maybe we can start with, Senator, I'm sorry, if you don't mind, we'll just start from the back, move our way forward. Speaker, if you can hold your questions. Thank you. Senator San Augustine.
Thank you, Madam Chair. You know, just reading the bill, I honestly believe everybody understands the threat that exists. In the water, GWA, you're doing what you need to do. We already know where it came from. It's all about the suit. Am I correct? It's about the suit. And it's about knowing where in line we're going to be. You know, it's kind of like you snooze, you lose. That's what it appears. We're trying to get ahead of the bus before the bus, or actually get in front of the bus before everybody jumps on the bus. Get the front seat. That's what I'm understanding from you, Fred, and also from the Attorney General. Now, going to the cost, on page 2 of the bill, it talks about agreement for legal services shall provide. Please explain that to me. Does that, or to the people of Guam, what is the bill that the government of Guam would have to pay to get involved? Because the way it appears is that you file the suit, they're like pro bono until you win, then you get paid for the councils in the states. It's just a matter of the Office of the Attorney General's office doing their part to make sure we stay well informed of what we need to, or maybe we just, maybe pay overtime for the Attorney General's office to do what they need to do. But my understanding is you're looking at using other states and other private firms that exist today. Basically piggybacking on the states that they got this train moving already and not waiting to be last, because at the end of the day, if there's any distribution of awarding by the courts, then we'll know if we're going to get any money to help GWA continue cleaning whatever and making sure EPA doesn't go out, federal EPA doesn't go after local EPA and so forth. And then the restriction will go in place for the fire department. You can't use certain chemicals to kill fires, and then we move from there. But if you can please explain what is the cost factor here? Because we already know GWA is doing everything they need to do. There's just maybe additional restriction they need to put on everybody else. So no further chemicals get on the ground and get to the wells. Mr. Agee, maybe you can explain what's the cost? What's the cost we're looking at? What's the dollar figure? If anything.
I'm not sure what the filing fee would be, because I'm not sure we would file the case. If we file in South Carolina, I don't know what their filing fee would be. I believe on Guam for district federal court, it's certainly a few $100s. It's not a huge expense.
No, but the Attorney General's office can absorb that cost initially, right? We're not looking at you asking. It's like what your letter said, Mr. Camacho. You said that if you had to file, and we didn't pass this bill, then you would ask us for money. You would ask for an appropriation so you can go hire whoever you need. But if we pass this bill, you wouldn't need an appropriation today. You would almost be able to absorb the costs, and then until we move forward and we'll see where it's going to go. And I understand the litigation is moving fast. If it was just December, that's quite quick. That normally takes 2 or 3 years before it even reaches this point. But it appears it's moving very fast. And that, I think, is the threat. We don't know that they say August 4th. They may even want to start closing the doors on anybody joining if the number starts growing going wild on numbers. But Mr. Camacho, maybe you can explain to us, what are we looking at on cost?
It would not, we would be able to absorb anything, so the government of Guam wouldn't have to give any additional appropriations. It would be a couple $100 to file, whether on Guam or in the district court in South Carolina.
Thank you.
Okay, thank you, Senator San Augustine. Senator Rigel.
Thank you, Madam Chair. Just to be clear, how much time am I allotted for this round of questions? Is it 5 minutes?
5 minutes for your own questions, but
Yeah.
there could be an extension
Okay.
based on their responses.
Okay, thank you. So my first question, I'd like to start out by perhaps this question should be meant for Guam EPA or any other environmental experts here. I want a clear understanding. I've done some research of my own, but I'd like to hear from you. What exactly are polyfluoroalkyl substances, and did I say it correctly, or PFAS? What are they, and are they toxic? And if so, what are the potential negative effects on humans?
Thank you. Senator Walter from Guam EPA. Excuse my voice, but yes, first off, there is a health advisory issued by US EPA for that chemical specifically. It is used to be for common understanding of common use. It's like Scotchgard. They've used it on that. They've also used it in firefighter training foam, which is the majority of where things come from, where that shows up in the environment. Yes.
What are some potential negative effects?
It is thought to cause chronic kidney failure.
Any others?
That one is the main one. There's still, again, the process of identifying a regulated contaminant takes a lengthy process as well, about 10 years. And we are not there yet as far as the studies being done. So anything else, you could surmise it may do it, but until the studies are confirmed, that's the one I can confirm at this point.
Thank you. My next question is for the Guam Waterworks Authority. How many wells have shown this substance in it? And can you tell us about, I understand some wells were shut down a few years ago because they contained this substance in it, PFAS.
So there have been a handful of our wells. I would say we have 120 wells total. Probably was detected in 3% at detectable levels. The only wells that have had elevated levels above the threshold, which created the concern among GWA, Guam EPA, and US EPA, were 3 wells primarily, and that's 825 and 823, both of which are located more closer to Agana, and then NAS-1, which is located, of course, up in the Tizen area. The NAS-1 well, as I mentioned, has, in the latest sample results, showed the levels to be still under the threshold, but at 50 parts per trillion in the raw water, but we're treating it so it's non-detectable. There are no detectable levels of PFOS in the water that's put into the distribution system. 823 and 825 have been disconnected. They're no longer in production. They are not connected to the distribution system, although we have been taking occasional samples to support a long-term study that Dr. Denton has conducted with regard to studying how the levels change over time. So we do take monthly samples from well 825 for that study, but it is not, and it still has elevated levels of PFOS in the hundreds of parts per trillion, but it is not producing any water that's entering the distribution system.
So 2 wells were closed, correct?
2 wells are closed.
Was another well closed previously and then reopened?
NAS-1 was the one we shut down originally while we did the work.
So just to be clear, 3 wells have been shut down, 1 was reopened, the other 2 remain closed.
That's correct.
Thank you. Mr. Denton from Wary? Mr. Denton? Yes, I have a specific question for you, Professor Denton from Wary, or Dr. Denton, excuse me. My question is, the aquifer, can you describe the aquifer? Is it true that the aquifer is an interconnected unit, so to speak? Is it an interconnected system, or is the system completely made up of different parts and components that are separate from one another?
Okay. Before I answer that, just make a summary of it. Before I answer that, I have to apologize because I don't hear you very clearly because of the acoustics, so I'm going to ask Miguel to summarize it for me, okay? Just give me a moment, please.
I think he's asking, is the aquifer continuous or is it broken into subbasins? I think you might want to describe the aquifer in those terms.
Okay. Let me make the point, first of all, I'm not a geohydrologist, I'm a toxicologist. But I do know from conversations with my colleagues at Weary that one can think of it as separated into discrete components or subbasins. Now, a karst limestone aquifer is extremely complicated, and it's possible that you can get flows of a contaminant in one subbasin to another. In fact, my own research with another contaminant implies quite strongly that that's occurring. But whether what you're talking about is, well, A23 and 25, and that's getting PFAS from another subbasin, I can't answer that.
Oh, that's not my question. My question was just whether or not it's true that the aquifer is, because of the karst topography nature of it, a very interconnected system. And I think you've confirmed for me that there is a possibility that stuff from one subbasin can leach into another subbasin. That's what you said, correct?
Can you confirm that something from one subbasin can migrate to another subbasin?
All evidence that I have on another contaminant, not PFAS, but on a pesticide, deodorant, suggests that's possible, yes.
Thank you. And finally, my question is for the Attorney General. Attorney General Camacho, you know, this is before us now, and one of the questions that's been asked of me is, why now? Why hasn't this litigation been brought forward sooner?
Before I answer that, there's a good movie on Netflix you should watch called The Devil We Know. It's actually a documentary about PFAS, and if you want to see some of the effects of PFAS and the manufacturers, it's available on Netflix. Why now? This is something we've been waiting for. I've looked back at before this body, there has been resolutions last year about PFAS, trying to get involved in studies. So this is an issue that people have been concerned about. When waterworks closed their wells, there were people that were upset, and this is something that's been an issue. So as the big pressing issue is that there is a case now that is moving forward, and if we don't join, there's a potential that we will not be able, as an example, some defendants may go bankrupt as a result of these proceedings. We would not be able to get money to help, and I'm not sure if Mr. Berdallo can confirm this, but all of this is being paid locally, you know, and in terms of how much it would cost to fix the wells that have been closed, maybe that could be a reason why we haven't reopened, because we don't currently have the resources to put the equipment in there. So this lawsuit would be able to tap into as many defendants as possible and as many financial resources as possible for remediation here locally. So we've been waiting for a long time. I believe the community's been waiting for a while, and we have the support of the governor, hopefully the support of this body, and our office is prepared.
Thank you. No further questions, Madam Chair.
Thank you, Senator Rogel. Senator Shelton.
Thank you, Madam Chair. For the Attorney General, when you say that the deadline for joining this lawsuit is August 4th, whose lawsuit is it? How many jurisdictions do we know are already a part of this?
So there are, I think it's 100 cases that have been filed across the country, and what has happened is, in order for there to be consistency in decisions and efficiency in terms of judicial resources, they have transferred all of these cases into a single district court in South Carolina. Sorry, so the question was, if you could repeat. I lost my train of thought. I was trying to explain just procedurally.
Yeah.
There are all these cases that have been filed. They've been consolidated into a single court in the District Court of South Carolina.
Okay, so there's a possibility that all of these cases combined, there could be a settlement that comes out of it, right? So if there were to be a settlement offered, who would determine if it's accepted or not? Each individual jurisdiction, or are we doing it as a group?
So typically in any type of multi-state litigation, they would develop a formula. There would be, for our National Association of Attorneys General, we have a multi-district remedies committee, and all they do is come up with formulas on how you would allocate settlement proceeds. So the Tobacco Master Settlement Agreement is the one that we're all familiar with, and Fred could talk more about it, where they basically said, based on volume and a bunch of other factors, this is how the money is going to be done. For opioids, that's the big discussion now. There are all these factors that they're trying to figure out how to allocate resources. If you look at states like New Jersey, New York, they have factories there where they manufactured this chemical. And clearly they would argue for more money and for settlement because they have a bigger problem, whereas Guam, it's primarily because of the use of firefighting foam. And we wouldn't have as strong of an impact on our environment as someone where there's a center there.
Okay, so if Guam were not to accept or agree to what the settlement division was, what kind of recourse would we have?
You would proceed to trial. And at that point, it would be whether or not there's any money available to pay. Because you can get a judgment against the defendant, and if they don't have any money to pay you, you're kind of left holding the bag. So that is the other potential danger is the amount of damages we're talking about is huge. These lawsuits, these hundreds of cases, may well bankrupt many of these companies that have produced, manufactured, and distributed this chemical. So if you don't get in line and are not part of a settlement, there's a chance you won't get anything. The judgment will be worth as much as the paper that it's written on.
Okay, thank you. So if the suit were to go after the manufacturers of these chemicals, would the principle of defensive non-mutual collateral estoppel prevent us as a government from going after suing those users of the foams like the Department of Defense later?
Really, we're talking remedies at this point, and this is part of the reason why we would want to have a firm that specializes in this type of litigation. One of the things that the CERCLA case that we have ongoing, as an example, there are certain things that need to be met from an environmental law perspective before you can file for monetary damages against the federal government. So there may be possibilities for non-monetary damages that you can seek under a theory of a standard tort law, but you would have to evaluate all the claims and see what's available. So even if we know to answer your question, no. There would still be a possibility to file claims against defendants if they're multiply and severally liable for the damage. It's just the remedies may be different because of sovereign immunity. So what you could collect from a private individual, you might be able to sue for $100,000. You may not be able to sue the government of Guam because of sovereign immunity. And the same thing would apply federally and in a case like this.
Okay, thank you very much. Mr. Berdalio, earlier you mentioned that one of the 3 wells were reopened. Which well was reopened?
NAS 1 was reopened.
And where is that located?
That's located in Tizen, close to the post office.
Okay, thank you very much. For the airport firefighters, we know that this forming foam, which contains PFAS, is commonly used by airports for training and to fight these airplane fires. Has the Guam Airport Authority used these foams?
Yes, we have.
Okay. So for the Attorney General, I guess, if it's found that the Guam International Airport Authority, which is a part of the government of Guam, used these foams and it happened to contaminate, let's say, the well in Tizen, which is very close by, with these chemicals, does the government of Guam continue to have a case in this matter?
Yes. I mean, I believe New York State is one case where they are both a plaintiff and a defendant. And then it just comes down to where the liability should accrue. Should you punish the firefighters for using something that they're required to purchase and to use? Or do you punish the manufacturers who knew about the harmful effects of this and continued to make it and market it? So if you could see there are several classes of defendants from manufacturer, distributor, and there are a bunch of defenses that are also available along the chain. The clearest liability would accrue to the makers of this substance and chemical.
And then for the airport, I assume that you no longer use these foams. Is there an alternative that you're using now?
Presently, the only time we would use it is in an actual fire.
Okay,
From
so
this point on,
you don't use it for training?
no.
Okay, thank you very much. And back to the Environmental Protection Agency. I wanted to ask if the source of these chemicals discovered in the Tizen well can be determined. If if we were to find a correlation between the airport use of the foam and the Tizen well.
So the Tizen well is within a BRAC parcel, which is how the airport got it from the Navy. And so prior use...
Sorry, can you speak? I can't really hear you.
I'm sorry. So the NAS-1 well is located in Teton, which is a BRAC parcel that was transferred from the Navy to Guam. So the Navy used it as Naval Air Station as well as Guam International Airport is using it. So there has been use by both entities firefighting foam there. So that is potentially the source.
All right. Okay, thank you very much, Madam Chair.
Thank you, Senator Shelton. Senator Pito Terlahi.
Thank you, Madam Chair. Before I share my thoughts, I just want to thank all of you for sharing this increase, if you will, for your input. One of the things, and I want to address this to the Attorney General, that the strongest point that you want to bring up on this suit is documentation, medical documentation of how many people so far has been affected by the contaminants of this water. Because I would think that that's going to be one of your strongest argument in pursuing this case. Do you have the numbers of how many people has been affected through medical records?
So my understanding of this chemical, Senator, is they're called forever chemicals because they never go away. So it will accumulate in your body over the extent of your life. In many of the bigger cases, so cows that have been drinking fish in rivers, they all have large, maybe there's 50 parts per trillion in the water, but if you drink that water over the span of 60, 70 years, Fred over here was saying he would be interested to see the coconut crabs that are out near some of these wells that have been shut down, and it would be interesting to see if you can find PFAS in that, and you can just imagine how many people for decades have been either eating fish from the water or
I understand that, but
so we don't have numbers of you normally would die from cancer, you wouldn't die from PFAS, and that's really what the main. If you go, the American Cancer Society has a page on PFAS. It'll tell you about the specific types of cancer. I believe thyroid is one of the ones that is most commonly associated with PFAS. So, no, you wouldn't die because of PFAS. You would die because of cancer that you have a result of accumulating PFAS in your system.
okay. Another thing, I was looking at the contingency write-up bill on the bill, and if you win the case, then you don't have to pay those legal fees and things like that. But I would think that if you win the case, maybe there's going to be less expense for the government because the companies that put these contaminants out would be responsible to pay for those. Don't you think so?
So the money that you would get in this case would be to pay for the harm that's
For
been.
the services
that's
of
correct.
those legal fees.
Yeah.
Okay, thank you very much.
Thank you, Senator Pito Terlahi. Senator Luis Muñoz.
Thank you, Madam Chair. At this point, I only have one question, and maybe I could reserve the right to ask it again once I get more information, but this is for GWA. How much has it cost the agency to test and treat for PFAS? Is there an amount? Can you?
Yes, Senator. To get the treatment system up and running for NAS-1 after we initially shut that well down, we put in about $200,000 in material, equipment, and labor to refurbish that. That includes replacing the carbon media that absorbs the chemical. So that was our capital improvement cost for getting it up and running. We anticipate we'll see between $100,000 and $200,000 a year in costs for monitoring and also for replacing the carbon because it does get used up as it gets loaded. So those are our estimates right now. For the other two wells, the monitoring costs, I'm sorry, I don't have a number for you, but it's in the thousands, I believe. And we're estimating that in order to put a treatment system in there to allow us to put both of those wells back in production, we're looking between $700,000 and $1 million in capital improvements for that treatment system.
For each For each well?
For both, because they're
For
so
both.
close together, we're trying to save costs by manifolding them together and then using only one treatment system for both wells.
Okay, thank you. I'll check later.
Thank you, Senator Munya. Senator Taitigui?
Thank you, Madam Chair. And thank you as well for everyone being here. As far as I'm concerned, this looks like a public hearing right now, and all the people that are at stake would be at that public hearing. And I do see a great urgency in this because it's not only the cost of litigation, which is in the hundreds of thousands of dollars, but it's the mitigation. That if we wait on that, it's going to cost us. Miguel, you said there's 120 wells on this island, and it's costing about $700 to $1 million per well to do this, and $200,000 per 40 wells to inspect twice yearly. So you multiply that 40 times to get to 120. That's a lot of money that the people of Guam does not have. And Miguel, if we don't get this, go after this money for those people who caused this poisoning to our water, where's that money going to come from? The ratepayers? The water ratepayers?
So the money that's been expended so far on the 3 wells that are the 1 well that has been impacted and that we have back online, that has come out of bond funds and revenues. So our operational revenues, which are derived from the ratepayers, take care of the cost of the operation and maintenance.
So the ratepayers would have to pay for it.
That's correct.
Mr. Leon Guerrero at EPA, and even Glenn, I noticed you kind of twitched when the question was asked. When these poisons go into our system or go into our ground, it seeps all the way to the water until it reaches water. But this poison does not go away. It stays. Is that true?
It is very persistent. That is correct. The research and science on still trying to figure out how it moves through the Veda zone and the groundwater is still being researched right now.
And as the director of EPA, even though there was only 3 wells that were identified, could there possibly be more wells to be contaminated?
Based on the current sampling that GWA has done and our review, not at this time, but again, what has been noticed by some of the science done is after heavy rain events, it'll show up more prevalent.
Okay, so it would stay. And though the US EPA designated 70 parts per million, is EPA, I'm sorry?
Per
Per trillion. EPA, are you following the same standards as US EPA?
Currently, we are following the health advisory limit that EPA standard. Yes.
So it has gone up. Mr. Camacho, I realize that not only that you have to rush this and its importance, but for the whoever you do decide to litigate this or who gets the contract, it takes time to come here also to do the research before presenting it to any court. So that's going to take weeks, maybe 3 weeks or so, so every day does count. And it was brought up earlier that this started in December. But we both know that the first suit began in Colorado 3 years ago. It was brought up then. And if I'm not mistaken, your office did make a comment that this was brought to certain senators back in February. Is that true?
Our office has we have been in conversations with some senators on the need for a contingency fee authorization so we could pursue litigation.
Since February?
I would say March, late February, early March.
And who are those senators?
It would be our oversight chair, Senator.
Sabina Perez, and who else?
No, it would be Senator Terlahi.
Terlahi,
Yes,
I'm
yes,
sorry.
Senator.
Sorry, Madam Chair. So she was aware of this since then?
It was just about, we had expressed a request for authority to retain a firm based on a contingency fee basis to pursue environmental litigation claims.
One thing I do agree in your statement, Mr. Camacho, is the section that cites that this confidentiality, and I truly believe that this is very important too as well when moving forward to these cases. It's just disheartening to find out now we're here today having to rush this and then people saying it's not important when we had the opportunity. The federal government, Mr. Berdallo, do you know of any contaminations in wells that are on federal properties?
I'm sorry, I don't have any data on any wells on federal property.
Do you collaborate with the federal government because of with their wells?
We collaborate with them on the One Guam initiative, and we meet with them biweekly, but on the topic of this discussion, I've only had conversations with the Navy, and my conversations with them have indicated that they do not have any detectable levels of PFAS on their facilities. I'm uncertain about the Air Force. I can't speak to that, I'm sorry.
On the Air Force. But the Navy says no, the Air Force hasn't given you an answer. In the fire department, you mentioned that you do not use these repellents, this type of foam for practices, but yet in the event it's needed, you are still using these contaminants?
That's correct. That's the only thing we have until the alternative gets put in place.
Knowingly, from the Attorney General's perspective, knowingly that these are causing chemicals into our systems that are potentially, more than potentially dangerous, are causing cancer, and you guys are still utilizing this foam?
We are discharging the agent on federal mandate as part of our annual certification is all we do. So it's a federal mandate on our part that says we need to conduct the testing, and that's all we do.
Okay, well, EPA, we need you to do something about this.
Right. It needs to be understood that currently this chemical is an unregulated chemical. US EPA has not put it in the list to regulate. So it was, as discussed, the ECMR was just to identify if it's in the groundwater. And, excuse me, which the wells that have it have been identified, and GWA has done above and beyond what I could require anybody to do because it is unregulated at this time.
I'm pretty sure something's going to have to happen sooner or later. So,
Yeah.
Last question, I think, Madam Chair, and I think I'm almost out of time. GWA, did you receive a $10 million DOI grant at all? And was that, if you did, what was it utilized for?
I know that we have received a DOI grant. I'm not certain of the amount. My recollection is that grant funding was provided for us to rehabilitate one of our spring sources. The DOI funds have not been used, to my knowledge, to treat any, to provide any facilities or enhancements to our system with regard to PFOS.
Well, anything that was used with DOI money to mitigate any of these wells or that has any relationship to these chemicals, I think it's paramount that you let the Attorney General's office know about this so that any kind of recovery of funds that we can get toward this litigation that goes forward, which we all pray it does. So thank you, Madam Chair.
Thank you, Senator Tatigui. Senator Moylan.
Thank you, Madam Chair. Attorney General Camacho, I think you made it really clear. I believe I understand your sense of urgency, but I'm going to replay it one more time in my mind, and I'm going to correct me if I'm wrong. So the litigation to me is urgent, and we're wanting to join, find attorneys that were wanting to work with us, and obviously they must be wanting to work with us to join in on this class action lawsuit. And these existing firms that are out there have already been chosen by the district judge as one group or one firm to represent those that are party to this litigation. And it's ideal that we use this firm so we can be added to their list because these guys are the first in line. Am I following you correctly?
So what has happened is all these cases have been filed in the classes that Deputy Attorney General Nishihara described. And then instead of having dozens of attorneys at all these hearings, they've created committees. And so there is an executive committee within the multi-district litigation that is responsible for kind of coming to the table and then communicating down the chain. So there isn't a single firm necessarily that represents everyone. There are just firms that have taken the lead and are kind of procedurally the ones to rein everybody else in. And in terms of, so they have some attorneys, some firms that would specialize in representing state sovereignties. And that's really where we will want, that would be kind of the starting point for us in searching for attorneys would be those who represent other states and other state-like entities. But no, there isn't a single firm. We would be open to going out and to seeing what's available for Guam.
Okay, so in our best case scenario, you're looking for that firm that is on top of the list so we can be part of that receiving before everything else runs out and we're forgotten. Is that correct?
That's correct. You would want to find, that would be one of the factors. You would want to find a firm who has experience, who's involved in it potentially, who has access to all of the experts, because that's just, sometimes these big firms are the ones that are going to be driving this, and that's who you'd want to align yourself with.
Okay, one other question on that. When we select this firm and the litigation that is moving forward right now, who specifically are we against? Who are we saying is, who are we complaining to? Who is it?
That's where we would need time to research the claims and to see all parties that are available. I know off the top of my head, 3M, DuPont, Chemco are the ones who make the firefighting foam. So ChemGuard, I'm sorry. Off the top of my head, but there are cases that it varies according to state and claim, and you're going to have different defendants in every case that gets filed. We would need to have the expertise to come in, evaluate the source of what PFAS is coming. So the unique thing about PFAS is no one else makes it. It is not something that you're going to, and that's why the liability will be easy to show because the only source of this chemical are going to be the manufacturer, 3M, and then DuPont potentially. So that's part of hiring the firm and getting them on board quickly so that we can review all these studies that have been done by EPA, GWA, DOD, and figure out who the best defendants would be for Guam.
Okay, so it's the manufacturing firm of this chemical that we presently are using. Is that correct?
That would be the easiest person to talk to about in terms of liability because they're the ones who created this and knew about the dangers and continue to manufacture it.
Okay, and I'm thinking our Guam firefighters here could be, this would be helpful if we are successful in this suit to help protect them because these folks are the one touching the chemicals and we have to help them in the long term if we figure out how these chemicals have damaged our body. So this will be obviously helpful for our firefighters who may contact some sort of illness because of using the foam.
I would say everyone at this table would benefit from this litigation, from waterworks to the fire department.
Okay. To include, we're needing to continue to change these filters on our water tanks as well. That we'll be using this, if we are successful, we'll be using this money to pay instead of using our general funds.
The goal would be to get as much money to take care of remediation so our local ratepayers aren't paying. It would be the people who've manufactured the substance that we're having to clean constantly.
Okay. Thank you, Attorney General. For Mr. Berdallo there, I recently received in my mail, I finally took the time to read this. It's a really nice brochure, but it's the Annual Water Quality Report for 2018. And it gives me all these numbers. Now I'm learning what it's all about because of the importance of this stuff. But one chemical, and it talks about all the other different chemicals that are found in our waters and what's the safe level and what's not. But what I didn't find here is PFAS, so I'm going to say congratulations because I'm still enjoying my water because you have safely protected us from this for now. Is that correct?
That's correct. There is no PFAS in your water. The report does not, because it's still unregulated, there isn't any requirement or maximum contaminant level, but we still are following the advisory level and treating it. But anything that is put into the system from NAS1 has been treated, and we found non-detectable levels in the finished water before it enters the distribution system.
All right, so thank you for you and your team for doing a great job. I appreciate it. And I hope to move this litigation as quickly as possible so we can get the money to help continue to get these filters put on and protect the people.
Thank you.
Thank you, Madam Chair.
Thank you, Senator Moreland. Senator Castro.
Thank you, Madam Chair. First of all, thank you to all the panelists for taking time out of your busy schedule to answer questions to what could perhaps be one of the greatest environmental catastrophes upon the community, not to mention and forget the potential harm against the population that lives here. I just want to state for the record before I get into my questions, Madam Chair, that according to the State Water Resources Control Board material, very brief reading, as well as the U.S. EPA PFAS action plan dated March 2019, there's no doubt in my mind that PFAS is a serious public health threat. My first set of questions will be directed to GWA and GEPA. Mr. Berdazzo, earlier in response to an earlier question, you responded by stating there was no detection into the system, and then later on throughout that commentary, you did say that the well water is detectable. The follow-up is a rhetorical question, and then I'll ask my explicit question. I get 3, right, Madam Chair? So my rhetorical question, go ahead. 5 minutes, okay, great. Then I'll ask several more questions. I don't think it'll be that long. The rhetorical question, actually, maybe I should ask it. I have time. Mr. Berdazzo, is there a chance that you could be wrong, that the filtration into the water well, for whatever professional reasons you might be able to provide me, may have taken time to get into the system? It may have occurred at times immediately after the use of this foam, firefighting foam, or any other byproduct thereof, because I suspect that the testing is not regular and it's probably not across all the wells. So my question would be, is there a chance that the tests that you had conducted for any other kind of chemical that may have not reported out PFAS or PFOS or any other of that class of chemical contaminant, that those reports could have been off, that there was contamination, but not at the time you tested?
I'm not sure if I understand your question, but the tests that we conduct are in accordance with the EPA methods that have been that the laboratory has used for the PFAS chemicals, and it covers multiple chemicals in that class. Is there a possibility that the numbers are off? I think it's highly unlikely for the samples that we've collected. If you're asking, has there been a time when these chemicals may have entered the distribution system? Prior to our monitoring, I don't know. There definitely, I guess, could be a chance that they did. The chemicals may have entered the distribution system. But since 2015, when we undertook the UCMR, and in 2016, when the health advisory limit was revised, I'm confident that the water that we've put into the distribution system has not contained detectable levels of PFAS.
This question could be applied to any member of the panel, Chair, but I want to go ahead, in the interest of time, directed to the EPA representative. Is any member of the panel aware of soil contamination from this forever chemical? Is it possible that although the foam or the byproducts of this chemical may not have made it into the water well or the distribution system or anything that would get into our body by way of the water, that in fact the soil and the surface, wherever it may have been used atop or near, is contaminated?
So, thank you, Senator. That's a good question. We have not actually performed any investigation to identify the source. We assumed, and we're assuming because of the use of Petizen, the firefighting foam is the source for A23 and A25 wells. We are still investigating with GWA on what the source can be. In fact, excuse me. In fact, the study that Mr. Berdazzo had mentioned that Weary was doing is to try to assist both agencies on the identification of the source for those wells.
Okay, in the interest of time, let me just ask a more direct question. Has anybody tested for soil contamination for PFAS or PFOS or any byproduct?
We have not tested for soil. WARI has submitted a proposal for testing soils to try and determine the source of the PFAS in the water.
Thank you. Thank you, GWA. Did you have a follow-up?
Yeah, so just so that there's a better understanding, soil testing for PFAS, you know, EPA goes through this long drawn-out science, and then they approve of methods, laboratory methods to sample. At this point, there is nothing set for soil.
I appreciate that. Madam Chair, of the record will reflect that no one on the panel has been able to state that soil has been tested for contamination. I do have a follow-up question to the Attorney General. Mr. Attorney General, are you suggesting that we may lose out on an opportunity to recover millions in damages, money that may be used to mitigate any potential harm against our people? And if yes, I believe you stated that twice, so it's rhetorical, but if yes, do you anticipate that the relief sought would tie into perhaps a long-term mitigation strategy as assisting with the testing of wells or soils adjacent to the wells, maintenance of effort, and or refund for expenses for mitigation that they already have taken to filter the water, be rid of contamination, and or for the damages done upon the people of Guam?
Yes, that is the risk, Senator.
Thank you. I think I still have about a minute and a half, Madam Chair, and I just want to go ahead and ask one more question. So I'm assuming that because you haven't tested the soil, you tested the wells and the water on occasion in accordance with your standards. I still think there's a different phenomenon we're dealing with here, and you might have to do it a lot more often than we think. In this case, I'm not saying do it now, I'm saying should we recover this? Do you test human beings after you've detected PFAS or PFAS of a certain percentage or the adjacent population? It's found, we reported it, it goes to you. What happens, what are the protocols when we find that we have been contaminated?
So a potential protocol with that scenario is we would invite either ATSDR, which is a subsection of CDC, to come in and do a toxicology review. We also have some toxicologists here that can help determine if the levels and the duration of the exposure would warrant a sampling of people's of the blood in the community.
Thank you. Thank you, Walt. I appreciate your responses. Madam Chair, I'll close with this. I don't have a follow-up question, but a closing statement, given the new information. So it's not a question, but a request. Should we have the opportunity to reassemble here with another panel or the same panel, I respectfully request that a representative from DPHSS, an epidemiologist, or somebody who is a subject matter expert can come before this body to speak to the health effects upon this community, to answer if, in fact, as my literature reflects, that PFAS can, in fact, transfer to the fetus through placenta and to the baby through breast milk, that health effects do, in fact, include liver toxicity, cancer, and or endocrine disruption. Those are the potential damaging effects of this forever chemical. Thank you, Madam Chair.
Thank you, Senator Castro. Speaker Munoz-Barnes.
Situ Masi, Madam Chair, I want to thank the panel for being here this afternoon. As some of my questions have been answered, I do have a couple as it relates to the types of cancers that are here for this PFAS contaminant. It was noted, and maybe someone up here on the panel can affirm, that kidney, testicular, thyroid disease, something my good colleague just shared with me from Barragata about the pregnancy-induced hypertension complications, and others that are literally well-known, that have been verified here on Guam that our residents may have. Is there, has any of the panel members been aware of any findings more recently that it was because of PFAS that there is a high rate of cancer here based on that? Can anybody answer that? EPA? No?
At this point, we can't draw any correlation to our cancer rates with PFAS. That study has not been done, Not by Guam EPA at this point.
Any findings, Attorney General, that you've heard recently in the findings, because you have noted that you've been working with some of our colleagues earlier, and the importance of this was real apparent, and to get on board, just based on what is happening in other jurisdictions?
I would say, Madam Speaker, that was one of the alarming things when you hear the types of cancers that are associated with this. We don't have access to that type of information, but we would just note that scientifically, I mean, again, American Cancer Society, you can go to their website, you can see the studies that have been done, that there are higher rates of cancer, particular types of cancer, when you have been exposed to this chemical.
Okay. And the fire department had noted, and maybe I can ask you, Chief Stone, I know that you were with ARF and in the past, and it was noted by ARF that the training is still mandated. The last time, does Gov Guam, not just ARF, but the Guam Fire Department, are they regulated to use that same kind of training and mandate that it has to be done on a specific time?
No, that is not a mandate for the Guam Fire Department. For foam, the use of foam in the training environment was mostly so that our newer members, our recruits, could understand the process of foam from solution to product. So the products that we were able to generate were very small in an effort to just make sure we demonstrate to our recruits so they understand how what a good foam product looks like at the end, and what it is used for. As far as operational use for the Guam Fire Department, we would only use it for the purpose of saving life and or property. For the most part, we utilize water to extinguish fire, but if there is a cause to use foam, as determined by the on-scene commander or leadership at the time, then that decision would be made. But as far as its general use, we only use it in the event of an emergency.
Right. So, in the last decade, has it been utilized by the Guam Fire Department or by ARF?
So, being new to the Guam Fire Department, I couldn't speak to the decade, but in my consultation with my chief staff, we have had opportunities or situations that require the use of foam for the extinguishment of fires, but they've been very small.
Okay, and to ARF, when was the last time that it was utilized for training with ARF?
For clarification, we do not use it for training, we use it for testing.
Or for testing?
So the last time it was used was May of last year for our annual testing. That's it.
And was it a one-day testing? Yes. Was it a...
Yes, it is. Our testing consists of discharging the agent, capturing it and taking readings from it, and once we get a result, then the testing stops. So it's not a whole day affair, it's just a matter of minutes per unit. And like I said, once we can pull numbers from the solution, then we stop the testing.
Thank you. I guess this would be for GWA, and I know you mentioned a little bit about it earlier on. Can GW share with us what measures are in place to mitigate the impact on the chemical in our waters? And I would also like to know the costs associated with installing and a filtration system, as well as the cost to operate and maintain the facility. And I know you spoke of it being anywhere from $200,000 to maintain, or up to
$200,000 to maintain annually one treatment system.
And to put it in?
To put it in brand new for the 2 wells that we're looking at right now, we're estimating between $700,000 and $1 million.
And out of those 3 wells?
The only one that has a treatment system currently is NAS1. That treatment system was existing, but we spent $200,000 to refurbish it.
To refurbish it. And
That's
to
correct.
maintain that well?
The cost for maintaining the treatment system, we estimate over the course of a year about $200,000.
$200,000 annually moving forward?
That's correct.
And that's coming out of the ratepayers?
That's correct.
Okay, I know that one of my colleagues talked about the funding from the Department of the Navy or DOI?
I believe Senator Tydek asked a question about DOI funding, and we have received DOI funding, a DOI grant, but it was for refurbishment of one of our spring sites, not necessarily for anything associated with PFAS.
So nothing for PFAS?
No, we did
that you're-
receive smaller amounts recently for training, which had to, and TAP technical assistance and their technical assistance program and maintenance assistant program, and we've used that for training, but not for anything associated with PFAS either.
So based on the wells being located in the central area of Guam, Hagåtña and Tizen, when the detection of PFAS was found, the effects and the findings of that were at what percentage per part was found in those wells?
If you're talking about the levels of PFAS that were detected in the wells that were impacted, they ranged from under 100 to several hundred parts per trillion.
For each, for all three wells?
Yeah, they vary. I can provide additional detail, but off the top of my head, that's
But
the
the
range.
allowable rate by US EPA is only 70
70 parts.
70 or 7 parts?
70 parts per trillion.
Point of information, Madam Chair. Is this a regulated rate or is this a health advisory? I think we should make it clear.
That's the health advisory level.
Thank you. I was just going to ask. So only because based on the other jurisdictions that I've heard, it's not 70 parts, but 7 parts. So I just wanted a verification to make sure that I go back and further research the amount allowable by US EPA. And know that if the contaminants are there, and here in Guam, we are literally seeing an increase of all kinds of cancer. And for me personally, one cancer too many. And if this is a way to literally put a handle and get mitigation fees to help our community, then I think that this is important. But I want to reassure the listening audience that if this has been looked at, you said the Attorney General had noted for the record that our community, including several members of the legislature, has been calling for this action to address this issue for years. And I know that the urgency now for the years is because the deadline is fast moving and it's August 4th. Was there a deadline before this August 4th when this PFAS contaminant came up to the forefront with all the jurisdictions? And why didn't Guam get on it before?
Yes, Madam Speaker. I do want to just point out, I know we've talked about regulated and unregulated for US EPA. And in terms of the significance, when it becomes regulated, my understanding is that's where liability monetary could accrue to the federal government. So you have this competing interest for US EPA to have standards, but the reality that once it becomes regulated, they open up the opportunity for suit against federal entities. So there have been articles written about this, the politics behind setting PFAS levels, and even 70 parts per trillion. And no disrespect to EPA or GWA, but just so that this body is aware that that designation, it's unclear what that means and whether or not it's what these other jurisdictions have set it at, whether it's 30 parts per trillion or in that range. But that is the significance. Once it becomes regulated, there is a potential sovereign immunity goes away for claims against the federal government for this contamination. Now, with respect to the deadlines that have been set, we want to be able to move quickly with our CERCLA case. There was a motion to dismiss because Guam may have missed the statute of limitations. So we are potentially pursuing millions of dollars to help clean ORDOT, and we may have missed out because we didn't act fast enough, we didn't hire a firm early enough. We don't want to be in that same situation where we're waiting, and the urgency with the multi-district litigation specifically is that there may not be defendants available to get the money, as you pointed out, that we need to pay $200,000 per year or even for the $1 million to build the facility, and it's unclear whether or not it would cost $200,000 to maintain that facility moving forward. So, you're looking at quite a large sum of money moving forward until it's gone. I'm not sure if I answered your question, Speaker.
Well, Yeah, the reason why I'm asking for that is because as we continue to see that new cases of cancers are coming up in our community on a daily basis, I think 1 to 5 on a daily basis, and then 2 to 5 die on a daily basis. That for me, it's really, really alarming. And if we have to look for the mitigation costs, I don't want it to be on the backs of our ratepayers when we can get money out there to mitigate this. And if we already missed the timeline the first time around, you know, the second time around, it's our fault, you know? And I'm saying that I literally only found out about this, me personally, because there was a conference and it was talked about it on the conference last week, and the environmental conference last week. And I want to thank EPA for bringing that conference to Guam again, because it was really important. And we, several of our colleagues that were there, had a better understanding, and that's the first time I heard of PFAS. But based on what I'm hearing about this, I also know that this is a man-made chemical that includes other components and chemicals that may already be here. And maybe just for the record, PFOA, PFOS, Gen X, and I'm not a scientist, and other chemicals that cannot be broken down. That means that would be in the system of a human body for many, many, many years. And as I look at the cancer rates, and there's 7 listed cancers and more rising based on information inclusive of, if I didn't say kidney disease, preeclampsia, liver malfunction, weak immune responses, diabetes, thyroid, pregnancy issues, just the whole weak immune system to a human body. I'm missing something here. If we don't at least come to the forefront and continue to make sure that we call all the government agencies in to address this issue. If this chemical that is affecting our community, even if it's just one, that we need to come up with some kind of solution or mediation to help control this, because we don't have that kind of money to give, or to mediate, or to advance, or to operate on an annual basis without affecting the cost of the ratepayers for water. And again, I'm literally fearful for the effects that are happening to our residents right now. And anything that you can do from the government's perspective to be the lawyer for the government of Guam, we need to jump on the bandwagon yesterday. So, and if there's any more scientists who want to put a plug in on how dangerous this component is, if you can't get rid of it and it's going to take more than 9 years, I'm almost afraid to ask, like my colleague from Barragata, what about the soil testing? And if nobody can't answer that here, I mean, if anybody can answer that here, what is it going to take for us to pay for testing for all the soil in our area?
I can only say that having read Weary's proposal, it's a 3-year research project, and I think the total amount that they were looking for was $308,000 to try and help narrow down.
One test.
That's 3 years of testing and analysis and monitoring to try and investigate and pinpoint where the source is that's affecting 823 and 825.
Thank you, Madam.
Thank you, Speaker. So I just want to clarify for the record, Attorney General Levin, so is it true that I was in contact with your office regarding the PFAS litigation?
No, I haven't been in contact with you, Senator.
Okay, thank you. Thank you, Speaker Barnes. Senator Kelly Marsh, I'd like to know.
Afide, and thank you all for being here. It's so important that we're going through this process. The more that we understand, obviously, the more helpful it is for making this sort of decision, and it's more helpful for the general public to be understanding what the issue is that may be affecting them in one way or the other. So what I want to look at is some of the ways that this might be affecting us in ways that we have not discussed thus far. So when you mentioned the treatment system, am I correct in understanding that we are doing this through a system of filters?
That's correct. We're using a series of granular activated carbon filters.
And what happens to those filters at the end of the treatment?
As the filters absorb the chemical, they get loaded, and at that when they can't take any more and you see breakthrough between the filters, that's when we change them out. The spent carbon can be shipped off island for disposal.
So they are shipped off island?
That's the current method that we understand for disposal, yes.
Okay, and so it's good to hear that it's not coming to our landfill, but it is also disturbing that something is so impactful and forever that it has to be shipped off island, and then I don't even know where it goes. The other is a question for perhaps Wary, for Dr. Denton, or EPA. Is there any way that this chemical is getting into our food chain? We eat a lot of coconut crab, that was mentioned earlier. Of course, we eat deer, banadu, babui. So is there any way that we know of or we suspect that it's getting into the food chain?
That's a very interesting question. And you're spot on. It does move in the food chain. It's highly bioaccumulative, hangs around in the liver, unlike some of the lipophilic compounds which hang around in the fat and is thereby put out of the way until you start going on a crazy diet and metabolizing fat, and then it gets back in the system. With PFAS, it's actually stored in the liver. So it's right there in the main metabolism, and is capable of interfering at any level. So to address your question, yes, organisms in the environment have been shown to bioaccumulate. That means they're accumulating levels higher than you would find in water and soil in their tissues. If you eat those, you would expect to go through the same bioaccumulation process too. Now, how much is too much? That's all kind of a gray area at the moment. You know, interest in PFAS and the toxicological aspects of it has really only become in the forefront of environmental research in the last 5 to 10 years, and really only concentrated stuff in the last 3 to 5 years. So your question is well taken. I can't give you all the answers you want, except to say, yes, it bioaccumulates. And it could conceivably reach levels which are toxic and start to do harm. Not all lipophilic compounds which are contaminants and are known to be toxic are in sufficient quantities to reach levels which do cause those harmful effects. And PFAS at the levels we're finding in some of our wells, particularly the A25 and A23, may well be at those levels which are causing toxicological thresholds to be exceeded in humans who drink the water. And in that, presumably, maybe I'm jumping the gun here, but my main interest is in identifying the source of PFAS, which is contaminating well A25 and its sister well A23. And it looks very much like that area is in the general Laguna swamp area. There are several possible sources in that area, ranging from urban runoff from the Sinahania area, injection wells up there, ponding basins up there, street runoff from the Agana shopping center. There is a number of possible scenarios we can come up with. Even the Korean air crash, it's conceivable that PFAS are coming from that site too. So my main interest is identifying those. And we are currently at Weary looking at soil samples. I was interested in soil samples a minute ago in the discussion. We're looking at soil samples from various potential sites, including Agania Springs, Agania Swamp, the Chout River, which for 20 years was pouring wastewater into that area, into the Agania Swamp, because of leaks in the pump station there. And we're following that up. Conceivably, if that gets into a water body where there's organisms which people eat, and Agania Swamp's got plenty of those, there are people who go fishing in Agania Swamp. So there are resources there which are eaten by people. Then there's a transfer mechanism. Whether they accumulate levels which are potentially toxic, I doubt they're potentially toxic in the short term, but who knows what's going to happen in the longer term. We don't know all those answers. So
Sujuis Masi for that. You know, when I was first thinking of that question, I was thinking of, as I mentioned, you know, the crabs and the deer and then so forth. But of course, if we're talking about soil and we're talking about the water, it can be taro, because many have been planting taro and harvesting it for years, if not decades, from the Agania Swamp. So incredibly disturbing, of course, and I believe that was the general area where something like 15 containers of soil had to be removed and either burnt or shipped off island, something like that. So, but let me move on to the next one. Is there a possibility, so this would be to EPA, is there a possibility that advisory levels will change, thus changing the level of concern and the understanding of danger? That something not considered dangerous now, if it's at 70 parts, but perhaps in the future with more studies, this threshold would be lowered. And so is that a possibility from what you understand of what's happening in this observation of PFAS? So, for example, of course, many of us are familiar with the fact that the tobacco industry for decades was said to be a safe industry, and now we know it's a leading cause of certain types of cancer. So within the industry, is there discussion that the threshold may be lowered in the future?
As Speaker Barnes mentioned, some states in their studies, they are looking at much lower numbers than the 70 part per minute or part per trillion that the health advisory that is issued by US EPA. So there are, depending on the studies that are done and who's reviewing it, it appears that there is a good chance it may go lower, but it's the process that US EPA does. And again, I think that's where there's a lot of confusion throughout the nation. Is US EPA is not ready to do their release any determining factors because the science is still being studied. But because, as a lot of your fellow senators have stated, the health effects are causing people to realize, with or without US EPA's long drawn-out scientific study, maybe things need to be done now. And so I think that's where we're at.
Sujuis Masi, so I would certainly say there's not room at this time to have a sigh of relief that we're only at 50 particles per trillion or 20 particles per trillion in some of our cases. For the Attorney General's office, please outline what procurement processes might be waived by the passing of this bill.
Thank you, Senator. So the procurement process first begins with funding. We can't even put out an RFP, a request for proposal, unless we have funding. We do not have the funding, so we cannot put out an RFP. But even if we had the funding, we would then need to publish it for a minimum amount of time. And given the scope of work that this case would involve, you would anticipate 30 to 45 days. I would expect potential firms to come back, ask for additional time of those 40 days, because of the magnitude of work that would be involved. So what you need to understand is the firms will come in, they're going to have subcontractors which are their experts, and so on and so on. And so you're lucky if within 90 days, and I mean, that'd be like lightning speed, 90 days if you have a contract. Lord forbid if you have a protest. If a protest occurs, then you go through the administrative process, including the OPA. You could go up to the Superior Court, up to the Supreme Court. So the way this particular bill is designed, it takes us completely out of the procurement, right? Like the AG had explained previously, we do have some objective criteria that our office is going to be working with. It's going to be developed by the people who basically do the procurement process. And basically what we're going to be doing is the evaluation of the firms, just the same factors the AG had said earlier. So that is what is being waived, the amount of time and the potential of protests that could occur with this bill.
So Judge Masi for explaining that. That's a very important consideration for us. What, if any, are the potential downsides to participating in this lawsuit at this time? Is there a downside? Will the people of Guam suffer in any sort of way if we pursue this lawsuit?
There's only upside really to get involved as early as you can.
You mentioned putting the case for Guam at risk as one of the potential damages. Are there any other potential damages or harms to our community that would occur by waiving the process to a public hearing in your assessment?
Everything that we've talked, you have to build your case. That's really what it comes down to. So the biggest risk is not being able to participate as Senator San Augustine said, you snooze, you lose. And that's the best way you can summarize this. If I understand 5 days, what's the big deal? If this bill passes, we're able the next day to go out and to begin one of the things that Fred mentioned, you published, but we would be able to actively ask other attorneys general, do you have any law firms who specialize in this type of litigation? We could go out and contact them, say, would you be willing to represent Guam? Could you send us your package? So that process, it's still going to take some time even to evaluate the criteria. It's just, I can't stress enough, the more time we have to think this through, to do the research, to put all the claims you can in, the bigger the pot available is for remedies for everyone. And when we talk about all the money that's been spent, the safety, all the mitigation, the sooner that we can file, the better it's going to be for us at the end of the day. So I don't really I can't say much more in terms of the urgency.
So Judge Masi, so I think in some of the different answers you've talked about this timeliness can affect the rate that we could be negotiating. It could be affecting the quality of our case. It could be affecting the quality of research. And as you're spelling out, can get to whether or not this is the best for Guam that we're putting forward or not. Can you explain the formula approach that is typically expected? So you spoke to this a bit and used to determine the amount of weight. So I think you said that Guam would fit into, at this point, the first tier of those. But if we're going out there against some of these states or larger entities that have a claim, where do we fit? Can you explain a little further where we fit into the suit?
So what the first thing we would do is we would start with firms who represent state entities. And I think Fred touched on this. They would want to get, their compensation is based on the amount of recovery that they receive for their clients. So you almost want to align with the states that have the larger amounts of damage because they're going to be the ones at the table lobbying for all of their clients. But at the end of the day, you're going to look at, the presence of factories would be one, the levels of PFAS, that would be another. I can't tell you all the criteria, but typically they would have folks that evaluate different ways, and then based on that, you would have a percentage. That's typically how it works. So for the MSA, I believe we get 0.05%, which ends up being $1 to $2 million per year, and that's just thinking about that, right? 0.05% of the total amount paid under the master settlement agreement is $1 to $2 million for Guam every year. So even if the percentage is small, depending on the amount of recovery, it could be huge amounts that we could use that would cover costs of remediation.
Again, it would address quite a bit of the remediation that we are going through, not only just may have to, I mean, we are actively going through it now. Who will approve the settlement agreement should one have been gotten? And will the legislature have any say in that settlement should the suit be found in our favor?
So this is typically you'd need to have authority before you go in, and any settlement would be subject to approval. The governor would have the authority to do that. This is where, though, it's a little bit trickier because for non-monetary relief, there would be a lodestar method that would, so the government of Guam could potentially have to pay if, for example, an entity is ordered to clean up the harm, the PFAS. So in that situation, the legislature, for any expenditure of funds under Guam law, is required to approve a settlement agreement.
And the last question that I have thus far, well, I have one other, but this is the last or the next to the last. You mentioned that transparency was important, that you would be providing information back. So how often would you be reporting back? Is this as things unfold, or would there be a monthly update? Have you thought about what kind of transparency you'll be providing us in this process?
I would say we would give updates on litigation. We would be open to quarterly, or if there are major developments, obviously we would be able to brief the legislature on that. But looking at the way things are developing now, so discovery is already going on, which means that documents are being exchanged. I believe experts are going to be testifying shortly. So within the, I guess backing up a little bit, the court has also issued a protective order over certain types of documents. So without violating a court order or law, we would be able to disclose information. But in terms of status updates, we would be more than willing to answer any updates that the legislature may have.
Sejus Masi. And this last one gets back to, and there may be no real answer to it, but I think it's helpful for us to look at and to think about, because we have talked about who's responsible for this. I think finding out the source can maybe be telling us some clues as to who is responsible for the PFAS that's in our systems and perhaps in our soil. Is there any discernible difference over the years that could help us identify? I mean, perhaps a PFAS is a PFAS is a PFAS, but is there anything that could help us differentiate, other than looking for the source? Is there anything about the chemical composition or something that's associated with, chemicals that are associated with it, or anything else that might help us identify? Or what are the strategies other than looking at the soil that could help us identify who was responsible for what? Partly so at the very least, we can be making sure that that activity is stopped. But can anybody at EPA or WARI speak to that, if there's any way to discern other than the soil samples and looking for a source
So
in
currently,
the soil?
yeah. So currently, what we do is look at the most likelihood of the usage of PFAS, and right now, that's the majority of the exposure to the environment is through firefighting foam. Second is probably landfills that accept it, and in some areas which Guam is not, it's where they manufacture the chemical itself. So that's generally what we have right now.
Sejus Masi. And did Dr. Denton have anything to add to that?
Okay. What's the question?
So just to clarify, the question was is there anything about the compound specifically that would help determine what the source might be, whether it came from foam versus some other source? Is that more or less the gist of the question?
Correct, or because I'm not very familiar with this topic, if there's some other indicator, something else that would provide an indicator.
Tricky question, but it really depends on how much you find. If you find if you find levels in soils, for example, in the high parts per million, I mean, I'm talking like 100, 1,000 parts per million, it almost certainly indicates sources from firefighting foams. If it's from urban runoff, wastewater, levels in soils will be an order of magnitude or more lower, in the low 1 to 5 parts per million. Now, you got that clear in your head. Distance from your well is important here, because if you have a concentrated source like foam, but the water which has in urban runoff has carried, let's say, the PFAS from the foams to a ponding basin 5 miles away, let's say, just for the sake of argument, then there will be some dilution effect. So you have to take that into account. Usually what happens, and this is what we would do, we're already monitoring soils on Guam on a limited basis, especially around the Agana area. If we find a relatively high level, and we're still finding levels in the parts per billion level, water is parts per trillion, so we're finding levels 1,000 times higher in the soil, we will simply go back and trace it up gradient to see if we can find the source. And that's the typical way you do it. We can take various guesses. Yes, well, there's a fire station over there, let's say, or there's a landfill there, so they're a possible source, but you don't know for sure. The only way to do it is to quick and dirty, take several samples over a wide area, because it's costing you $500 to do analysis of one sample. So you spread your effort as far as you can, and if you get a hit, a high level, then you start focusing more closely. Up gradient, left, right, so on and so forth, until you finally pinpoint the source. And based on the levels you find at the highest point, you can make a stab. Well, this is probably from firefighting foams, or this is probably from a dump site, let's say, a municipal dump site, or a leaky sewer pipe, something like that. So there's a certain amount of logical guesswork which goes along with this. Now, if you see firefighting foams being used, that's a whole different ballgame. You could, in Saipan, for example, in the airport, they have relatively high levels of PFAS in the soil. Over time, since they've stopped doing that, the PFAS is washed down through the soil profile. We only looked at the surface samples. Relatively high, in the 10 parts per million, which is not enormous, but bear in mind that they haven't been doing this sort of thing for at least 10 years. The next thing to do would be to do a depth contour, depth profile, to see if this stuff is moving down through the soil. We know it is, because there's high levels in the underlying wells, but are we past the maximum input level, or is it still chromatographing down through the soil, and it's going to get better before it's going to get worse before it gets better? So it's a long, drawn-out, costly procedure. For me, it's great. I enjoy that sort of detective work, but it takes a long time, and it costs a lot of money.
Sorry. Thank you, Senator Marsh. We're going to, for the next round, we could save it for the next round. Senator Therese Terlahi.
Thank you, Madam Chair. I want to thank all of you on the panel for your answers and your forthrightness with us today. It's been very refreshing and very helpful, I think, for our deliberations, and we're being asked to act urgently, and so I appreciate your responses because there's a heavy weight on us to act urgently on behalf of all of the people of Guam. I 100% support litigation based on a contingency basis for environmental causes for Guam. I think that's a recent case under CERCLA with that the last Attorney General took up regarding the Ordot dump and the contamination there. was one of the most exciting things to happen while I was in office, I thought. And because the lawyers that came along with it gave us a lot of hope. They told us that, you know, how they had succeeded in other jurisdictions, and they told us, most especially, I thought exciting was their discovery process, and that during discovery in their cases in other jurisdictions, you know, that's where I thought Guam had the most hope. For in these cases, during the discovery, that we are going to find out a lot of the truths about past injustices. So for example, in the CERCLA case, one of the things we talked about a lot over the, you know, since that began, and even this year, I know, with those lawyers, was the potential of, during their search for what was contaminating ORDOT dump, that they might actually be able to prove Agent Orange, or, you know, trace the Agent Orange. And they were so very interested in I know that they've kind of, you know, many instances of contamination on Guam. So generally, we've talked a lot about this, and so I think there's a great potential in this lawsuit. And so I'm glad to hear of the evidence that we have before us. I'm very much looking forward to the evidence that we will learn about, you know, other potential evidence that the AG might put into this case regarding contamination of water, or if soil, or of people. And I don't know, I'm going to ask later about that. But so in these many discussions regarding the CERCLA and expanding it, you know, perhaps to check Agent Orange and other contaminations, we know of the PCB in Moleso Lagoon. They've been reporting about that for years, and at Tengisan, and I think off of Agate. Those are the ones I just remember. And so many, it's true, many in the community have been talking about this for years. And particularly, you know, I know that we've been going back and forth, my office with the Attorney General's office, regarding a potential bill to allow additional environmental litigation in addition to that CERCLA case that's ongoing right now, and what would be discovered under that CERCLA case. So again, I am learning a lot today here and during this hearing as to how this really transpired, and I'm very glad to get the details. I really believe that transparency is, these are injustices that have preceded all of our terms in office, maybe all of the terms of these people. If these wells were contaminated, you know, years ago, and I think we're still discovering that, right? So I just think that working together and transparency is really going to be the only way to go on these types of matters. They're bigger than any of one of us, and they're injustices that we've all kind of heard about, but we are pursuing. So I want to give a lot of credit that if we can get in on this PFAS case, and I have utmost confidence that the Attorney General's office is going to be able to do that. Especially Fred, I think the information that you provided today has been very refreshing. In all our discussions going back about environmental litigation, and I don't remember discussing PFAS in particular, or that you were looking at a multi-state litigation, or that there were any deadlines involved in that until after the governor's call to session. So, but even the information received right after that call, which was very good, but today's is just, so for me, very much more informative. So I want to thank the chairman for this opportunity. For example, we learned today that Mr. Nishara, it's correct, you just learned the deadline of this multi-state or multi-jurisdiction, the case deadline to be the August 4 deadline. You learned that in June. And I'd never heard that either, right, until after the governor's call. I wanted to ask a couple questions regarding the contamination that we're talking about. So you're doing some testing, I guess, to trace the source, but do we know, do you have tests that tell you how far back that went? Like, what's the earliest that you knew of this?
No, I'm sorry, Senator, we don't have any method of determining how far back it may have been in the system. All we have is the data from the time that we started testing for this particular compound or sets of compounds under UCMR 3.
What's your earliest date that you know?
We have data as far back as 2015.
All right, that's very recent. All right,
Senator, can I add to that?
Yes.
So, though we don't have the analytical know-how to age the contaminant, we can look at the history of the use. So, again, prior to it being transferred to Guam, it was a military facility, and they did use it. So you could actually try to gauge it from the actual use of it for the firefighter up at NES. Excuse me, sorry.
Thank you. In the, maybe Mr. Orcutt or any of you, Attorney General Camacho, in the circular case, in the motion that you said was filed saying that Guam didn't meet the deadline, what does the deadline that, is that the Department of Defense is saying there was an earlier deadline, and when would that have been in that, what's their theory of what the deadline should have been?
The CERCLA deadline goes back, I think the federal government is claiming they should have been filed, or that the statute of limitations ran, I believe, around 2006. And it's whether it has to do with the consent decree or the settlement document that was signed, and it was whether that document triggered the running of a statute of limitations or not. So it had to do really with the scope of the settlement agreement, what it covered and what it didn't.
All right. I wanted to know if the AG's office in beginning this case, or are you aware of any contamination beyond what GWA has discussed today, that the wells, those 3 wells?
I know that the Department of Defense did a nationwide study about military installations, and there was a comment that we don't have testing. I want to say one of them tested above 50, and I'm not sure if it was above 70 parts per trillion, but really the controversy is over what the level should be, whether it should be 70 parts per trillion or whether it should be something lower than that. So, and I'm not sure, I haven't reviewed GWA's study in terms of how extensive the sampling was. I believe that for the DoD study, they only tested 4 sites on Guam randomly selected. So you are seeing just, I believe in New York, they've actually separated out their claims, those for non-military installations and those on military installations. And my understanding is that the non-military are the ones that have been transferred over to South Carolina. So there's probably a lot of information that's out there that we do not have access to. And you know, that would be part of the discovery process. But just based on our review, we've just been able to get whatever documents are available publicly.
All right. Is in the cases that you've seen across the different jurisdictions, I know that some of the other speakers asked about who the defendants would be, but who are, and you talked earlier about who the plaintiffs are, so individuals, of course, the government, the states and municipalities, but so who will be the AG's client in this case, if in like a multi-state jurisdiction? Would it be the government of Guam? Is it possible for you, will you have to put in individuals also, or no?
It would be on behalf of the government of Guam or the territory of Guam.
Okay. So individuals who perhaps think they've been affected by this, what would they do? Do they need to get their own lawyer, or would they be covered by this also?
I think in that case, they would have to retain their own lawyers, but the theory is that a state would be able to get the recovery to remediate and to take care of their costs. So the same thing with tobacco. It wasn't individuals, it was states that received the money so that they could take care of the healthcare costs across the community.
All right, I think that's what one of the circular lawyers told us about Agent Orange. They remediate it by cleaning up the entire river and surrounding areas. Is my time up, Madam Speaker? All right, thank you.
It was brought
thank
to
you.
my attention. We can go on round two. Senator Sabina, I will address you, and then I think Senator Lee would be next. Senator Sabina, please proceed.
Thank you, Madam Chair. So, let's see, what's the question? So the question I have is for Assistant Attorney General Nishihara. So you were mentioning earlier about the multi-district process, and you broke it down to 3 different types of litigants. There's the individuals. Can you state those?
So the 3 type of plaintiffs that the judges is kind of sorting the plaintiffs into are government and government entities, so states. If you have city and counties or parishes, they're categorized in that. You have private water providers. So for example, I believe Pepsi-Cola Guam or Foremost, right? They would be a private bottler of water. So their product was obviously affected. And of course, you have individuals who bring their individual claims.
Okay, so if the client is the government of Guam, which of those categories would we fit under?
We would fit into the government category or government entity category. And although this has not come out, can I back up just a quick minute? Because per Senator Terlayu's question on with regard to the MDL, it's also available on the webpage. So as soon as it comes out, all the orders come out immediately. So the information is provided for almost instantaneously. I'm sorry, Senator Perez. Could you repeat your question?
Oh, just you answered the question about which of these categories would we fall under, and you said it's the government entity.
That first category, and my understanding, and Ken can help me, he's a much more experienced litigator, is my understanding is that category will go, when I say first in line, the judge wants to hear all those that fit in category 1 first.
That's correct.
Category 1, again, is the state governments? Okay. So how does the litigation differ between those 3 categories?
The state governments would include municipalities and other governmental entities. And would be those entities that actually operate municipal water systems. And that would be distinguished from individuals who have personal injury suits that are saying that because of the chemical that they have suffered, health consequences, are seeking damages for that. The judge, it's my understanding the judge has separated out the personal injuries, thinking that if there's no remedy against the governmental entities, it's unlikely that the individual people seeking damages would prevail. And of course, their claims as individuals is much more individualized as opposed to the kind of overarching issues that the governmental entities would have to say that, well, we've been harmed, our water, supply is contaminated, we need help cleaning that up.
Okay, so what we would, go ahead.
If I can further, I mean, the nutshell of it is, right, government, the states, they protect the natural resource, in this case, water, right? And we say, the way the suit would say is, your product caused damage to our water. Pretty simple, straightforward case as far as evidence is concerned. And if we can't prove that case, then it'd be much more difficult to the private water supplier to prove the case, and even much more difficult for the individual.
Thank you. So we could potentially pursue those different angles. Should we succeed in the government case, there could be other cases such as the individual harms case.
Yes, it all depends, of course, on what the relevant causes of actions are and what the statute of limitations would be, which at this point we're not aware of what they are.
So, Attorney Levin, you were talking earlier about how in a multi-district setting, there is maybe one big settlement and it gets divvied up, allocated to the different entities. Would there be any opportunity for our government to have parameters as far as acceptance of a settlement. What I have in mind is potentially exonerating other potential parties other than the manufacturers.
So usually, if you settle a case, it's only to the parties that are to the action. If there are parties that are not included, they would not be bound by a settlement agreement or for a cause of action. And I kind of adding to a little bit of what Ken said, there may not be statute of limitations problems, but there are remedies available against these defendants, which I think would be much more realistic, that they're going to bankrupt down the chain of these defendants, which you wouldn't have necessarily against the federal government. So you can distinguish a private defendant versus the federal government. Maybe the federal government would also go bankrupt, but it's a lot less likely than a private party would in terms of remedies. So to answer your question, no, if you were to file and settle against the manufacturer, 3M or DuPont, that wouldn't preclude you from filing against someone who's not part of the settlement agreement.
So the other thing is that there's a lot of changes going on with PFAS. There are more chemicals being produced. We don't know the full health effects of PFAS. What is the risk of settling too soon so that these effects are not covered or these chemicals are not covered?
Again, I would just point out that depending on how big the damages are against these companies, which we're talking large sums of money, there may not be any companies left to sue at the end of the day for this. So that's the real risk, is that you're going to wait, these companies are going to go bankrupt, and there will not be any money available. Now, in terms of the levels and what's not known, I think part of the reason why these are now being looked at is because of litigation. Litigation against 3M and DuPont, and now it's on the radar about what the dangers are, because through discovery they were able to identify all the information that these companies had been sitting on for decades, and they knew how harmful it was, and they continued to produce and to sell. So I think a lot of the regulations you're seeing are in direct response to information that was produced through litigation.
Senator Sabino?
Yeah, I just, is there a way that we can create our own parameters as far as settlement is concerned? And when do we make that determination? So let's say we were given $1 billion, but yet we have to sign off saying we can't sue anybody anymore. I mean, what type of parameters can we create as a community in this process? Or how do we engage in that?
It's really difficult because if it's going to be set by percentage, as I mentioned, if you told me I'm going to settle your claim and it's going to be 0.05%, I probably wouldn't accept that. But when I told you that it's going to be $1 to $2 million a year, that sounds a lot better than 0.05%. So in terms of setting a hard parameter for settlement, I mean, if you a dollar amount, I guess if the legislature would want to set a floor for a specific dollar amount, you could do that, but just the way settlement agreements work, you only will settle your claim against the parties to the action. You wouldn't be waiving your claims against other actors who may have done something else to cause harm. So under tort theories, typically you have parties who were jointly and severally liable for the harm, which means there are all these people that were involved in this amount of damage, right? Right now, what's available to us are the private entities. That doesn't mean that somebody else later on, proving $1 billion worth of damages, but these companies can only pay out $100 million. There's still $900 million you would need to recover. So you would be able to go potentially after other people who were liable under a theory of tort. So that's, I'm not sure if that's a satisfactory answer for you.
Senator, maybe I can be a little more simplistic. The beauty about this is a contingency fee. And the one thing about attorneys is if you tell them you get paid based on what they are able to collect, they will fight hard.
This is for me. This is good for now. Thank you.
Si Senator Perez. Senator Regine Pisculi? You're recognized.
Sujos Masi, Madam Chair, and thank you all so much for being here and for answering our questions. This initial question is directed towards GWA. Mr. Bedallo, one of my colleagues discussed GWA's recent newsletter, and some others have asked if per or polyfluoroalkyl substances are present in the tap water. And some members of the panel have mentioned that PFAS is not a regulated chemical. So my specific question for GWA is, if PFAS is not reported because it's not required to be reported, or is it not reported because GWA only measures that substances that are not or at detectable levels? Because you mentioned that they're at non-detectable levels, but I know that that doesn't mean zero. We can't say zero. So is PFAS not reported because it's not required to be reported, because it's unregulated, or is it not reported because GWA only measures it in non-detectable levels?
So with respect to what's in the Consumer Confidence Report, the brochure that's gone out, we're required to produce that annually. I'll just point out that those numbers are primarily a requirement of US EPA for us to report on all chemicals that are that we're regulated under, right? And so that's the primary purpose. We do provide additional information on some of the other contaminants that may not be primary or part of the primary drinking standards, but we still do report on it. But the reason why PFOS does not appear on that report is because it has been non-detected in the distribution system samples that are collected from the system. It has been detected in our wells, and only, as I mentioned previously, in the raw water, but after the treated water, it's not detectable.
Thank you. And my general question for all panel members or any panel members that would like to respond is, what are some differences in researching, monitoring, reporting on PFAS that are not required or are required for, basically I want to know about unregulated versus regulated chemicals. So what are the requirements for reporting and monitoring and researching when you're looking at regulated chemicals versus non-regulated chemicals?
So when a chemical is regulated as a contaminant, there are strict guidelines that you have to follow, especially when they're when they're identified in the groundwater or in any other medium. This one came to light during the UCRM 3, which put PFAS as a unregulated, but for lack of a better word, interested contaminant that we need to start monitoring for, which is kind of the process of getting to being a regulated contaminant. So with that being said, GWA was required to perform quarterly sampling of this contamination. When they identified it, and Miguel can speak more about this, but when they identified it, they sampled those wells more frequent, and through the efforts that they've done, they ensured that none of the water from the impacted production wells were introduced to the distribution system. That's the statement that none of the people of Guam are drinking this water from GWA system.
Thank you, Mr. Leongaro. Chief, thank you very much for joining us. In the document that was circulated by GFD, it notes proprietary hydrocarbon surfactant and proprietary floral surfactant, and they're highlighted. So I just wanted to ask, do these mixtures contain polyfluoroalkyl substances, and if so, at what rate?
Thank you for the question, Senator. However, those are a lot of 10-letter words that I'm not really good at pronouncing, and that's just to say that I'm not familiar with the actual chemical makeup of foam. from the chemical level. I know how it looks as a solution and how it should look as a product at the end of a fire nozzle. But to what percentage makes up the chemical itself or the product itself, I'm not familiar with. So from the MSDS that we did provide to you, that basically is required to provide that breakout for you. As far as specifics, I think they're not required to provide the specifics for if it's proprietary to guard from trade secrets. They provide you with the basic chemical makeup of the product. So.
Thank you. I'm just trying to figure out in my mind if this is the same type of chemical that's found presently in human lungs. I know that we all contain like pulmonary surfactant chemicals in our lungs, and that's what allows us to breathe air in and out. That's, when little babies get to a certain stage in their mother's womb and the surfactant is present in their lungs, that's what allows them to live independently outside of the womb. So I'm familiar with that chemical. I'm just concerned that the chemicals that you have listed in terms of hydrocarbon surfactant and fluorosurfactant, if those might be, those have certain rates of PFAS and PFOS that might be concerning when we're looking at, using it for training, as was mentioned by the folks at ARF and other kinds of training measures. But I appreciate your response. I think one of the other questions that I wanted to ask, Madam Chair, is for the panel, are any of you personally or in your agencies aware of any DoD-related PFAS exposure on our island?
I'm not sure if I'm going to answer this correctly, but as mentioned before, the Tizan area, which is the former Naval Air Station, was a DoD property that was transferred to Guam. And when it was a DoD property, there is evidence of, or at least archival documentation, that they did utilize the firefighting foam that did contain the PFAS. So as far as that's the answer you're looking for, that's what I could state, yes.
Thank you, Mr. Leon Guerrero. And just to go back to you, Chief Stone, just as a follow-up, the foam that you're referencing, is that AAAF? Is
AFFF?
AFFF,
Yes,
aqueous
Senator.
film forming foam?
That is correct. Very good.
I can't say that five times fast.
You did it
but-
really well.
Okay, just wanted to confirm that. For Attorney General Camacho, I understand from the previous line of questioning that you have pursued authority for environmentally regulated litigation. And given the limited scope of this bill, my question is there any potential litigation that is time-sensitive or emergency?
At this time, this is the only case that we can see that there's some real urgency because of the multi-district litigation.
Sutos Masi. Thank you, Madam Chair.
Are there anyone else wishing to speak? Senator Perez, I have a question. So. Senator Tello, for an updated question.
Thank you,
You are
Madam
recognized.
Speaker. My question is to the Attorney General. I just have one question. My question is, this piece of legislation that's before us, is there any amendments that you want to recommend, or is the bill perfect the way it is right now?
We have no concerns with the bill as proposed.
Okay, thank you.
Okay. Speaker Barnes.
Yes, I do have a question, Assistant Attorney General, based on the definition and what this bill is limited to for the PFAS. And as I noted earlier, that there was the PFAS is a group of man-made chemicals that have been in use since the 1940s. And earlier I spoke about the chemicals that include the PFOA, the PFOS, Gen X, and many other chemicals. And one I wanted to ask you was, on this bill, your definition on PFAS is just a broad definition of, let me get it here, means a class of chemicals known as per and polyfluoroalkyl substance. But here, I have some information with me that there may be these chemicals that would include, for the background, for PFAS, but also include chemicals of PFCs and PFCs. So I just want to make sure that maybe I can make a motion to have the definition of PFAS further defined and give legal counsel the opportunity to make that. And I wanted to know if would that help include so that we don't miss out on anything? Or will this meaning of PFAS right here, a class of chemicals known as per, but I do know that there are other components that may need to be included in. I don't know. If there's a scientist here that can help?
Well, just from looking at some of the complaints that I'm looking at Vermont right now, they have referenced PFAS, and then they've kind of used PFAS to also include PFOS, PFOA, PFNA, PFHXS, and PFHPA. So those were all, I believe, compounds that fell within the broader rubric of PFAS, and that would be something that we could kind of define in the litigation itself. But I guess if there were to be an amendment, it would be and related substances if you wanted to potentially expand. But that's just the way it's been handled in other jurisdictions.
Well, that's why I just wanted to ask if I can make a motion on the floor for the definition, Madam Chair, and then give legal the opportunity to work that whole definition down based on what I see is noted, based on making sure that we get all the components, any and all, an additional substance that relates to.
Yes, most definitely. And I just do want to clarify, PFAS covers everything. It's basically, it covers all the chemicals that are fluorinated, even the ones that are emerging. So it's the broadest category. So the PFOS is just it's a subset of PFAS. Yeah. But yes, thank you for that amendment.
Yeah, so if it just includes in other jurisdictions I just making sure that the definition is clear, even if it's.
Let's actually, we can postpone the amendments to the second part of this committee in the whole. We're just here on the question and answer part. So
Okay.
we'll entertain that in a later part.
Right after the panel.
Yeah, after the panel discussion. Okay, so are there any further questions from my colleagues? Okay, so I believe we kind of got out of order here. So let me go one round, full round. Vice Speaker Nelson.
I'd like to thank the members of the panel that took the time out to be here today. I do have one question, perhaps just for public information. Can you just explain the timeline and process that the transfer of the DOD wells that were contaminated with PFAS, perhaps the Airport Authority or GWA or EPA? Timeline as when the government received these wells, the mitigations that took place, and the levels that were detected, and what timeline during the years. Thank you.
So if I'm not mistaken, and I could be a year or so off, when DOD finally vacated Naval Air Station was about 1995. The actual turnover and exchange of quitclaim deeds was done in 2000. So basically, Guam has been in use and managing NAS1 since about 1995.
Okay, and can you give us the years that PFAS was detected and the measurements of the contamination within the well?
So PFAS was first detected as part of our sampling in 2015, and the level at NAS1 was 110 parts per trillion.
And that level, the 110 parts per trillion, was there a mitigation before it reached the filtration system that made it non-detectable, or was this in the raw water that was being?
That was the raw water sample. Prior to that, there was a carbon system in place for a different chemical, but it's the same sort of filter that we currently use for PFAS. So there would likely have been some filtration of any PFAS in the raw water when that system was active.
Thank you. So the first time PFAS was detected in NAS1 was in 2015? I'm sorry, let me rephrase that. The first time PFAS was tested was in 2015?
That's correct, yes. As stated earlier by myself and also Miguel and Dr. Denton, it's an emerging contaminant. We did not know we didn't know that the ill health effects that are associated with us. Unfortunately, that is how a lot of the contaminants that we regulate are. Lead-based paint, it was done at everybody's house. We never knew that there was ill health effects till later on. Then you had to take remedial measures to take care of that. So a lot of these things have taken time to realize that there are possible ill health effects that they carry. And until we know that, a lot of times they're in general use in the community.
Thank you. Thank you, Madam Chair.
Thank you, Vice Speaker. Senator San Agustin.
Thank you, Madam Chair. I'd like to thank the participants in the Committee of the Whole. Thank you for the information you provided. And I'd like to thank the Attorney General for pursuing this. And I hope that my colleagues would support to expedite this and allow you the opportunities to do what you need to do, which is actually to fulfill your responsibility as our legal representative here on Guam. But I don't want to ask is that I'm only hoping that EPA and Waterworks is also testing on the other bases, Anderson and Navy. I'm going to assume you are. And the only reason why, because if you found it on NAS, it's probably an Anderson and Naval Station. And if you find it, if you could just please share the information with us so that the people of Guam will be aware of what's going on the bases. Okay? Because the water will come out. It will come to us.
Yes.
That's what the...
So Senator, I do want to indicate that DOD has a plan or a program in place that they are sampling any and all of their production wells, and they did that already. And now they're in the process of trying to sample some of the monitoring wells to try to see if there's any levels of PFAS in the groundwater.
Okay. Thank you. Thank you, Madam Chair.
Thank you, Senator San Agustin. Sorry, did you want to say something? Okay. Senator Rigel.
Thank you. All right, my first question is for GWA. Forgive me if this was answered earlier. If it was, I just want to clarify it. The 3 wells that were tested to have this substance, the PFAS, and that were shut down, when was that? I looked it up online, I just want to be sure, but when I looked up online, some of the articles indicated it was around August of 2016. August of 2016, is that correct?
That's correct, Senator. The change in the health advisory level from EPA was a month or so prior to that, and then subsequent to that, we had a teleconference set up to address the concern that US EPA and Guam EPA had, and on the basis of that coordination and that conference call, the decision was made to shut down those wells.
Now, I know it's difficult to ascertain the potential cause of what resulted in that, in the PFAs to be found in that well. But are there any ideas, anything it can come from? We know it can come from firefighting foam, correct?
That's correct. We understand that foam is a potential source of the PFOS, and that seems to be the general consensus of the stakeholders that are involved with regards to its presence at NAS-1. We are uncertain as to the source of those compounds in 823 and 825.
All right, so do we have any idea of when, so it can be found in firefighting foam, correct? So do we know if any fires were extinguished using firefighting foam in and around that area sometime near the time frame of those wells testing positive for that substance? So, go ahead, yeah.
No. There wasn't any fires at those times.
For the airport firefighters, correct?
That's correct.
There was, however, prior to that, about 3 months or so prior, in May of 2016, there was a crash on Andersen Air Force Base that resulted a B-52 bomber that crashed on the flight line of Andersen Air Force Base. Do any of you know if that type of firefighting foam that contained the PFAS chemicals was used at the site of that crash?
Senator, so when I was in my capacity with the Aircraft Rescue and Firefighting Division of the airport, I was one of the responders up to Andersen in support of that crash. And at that time, foam was utilized in order to extinguish the fire.
And that foam contained PFAS?
It's my understanding, I am not the expert, is that that chemical is present in all makes of foam, and maybe I'm overstating.
And that was on May 19th of 2016, somewhere thereabout?
That sounds correct, Senator, yes.
And then it was just a few months later that it showed up in those water wells, correct? That's for GWA, I guess.
It was detected in 2015 in our water wells as part of the UCMR sampling program.
Okay. So, and I guess the next question is for Mr. Denton. Is there any way to determine whether or not it's possible, I'm not saying if it did happen, but whether or not it's possible that the chemicals from that firefighting foam that was used at that crash could have made their way to those wells that tested positive?
You know, anything's possible.
Thank you.
Especially on Guam.
All right, thank you, Mr. Denton.
But
fair enough.
You know, based on...
My next question is for Attorney General Levin Camacho. Now, we're kind of getting deep into the weeds here with all of this, and I am a bit concerned that this is a court case that is pending, or litigation that is pending. Is there any possibility that by us asking too many questions and maybe you answering too much, that anything here could be used by the defendants against you in this litigation?
At this point, nothing we've shared here is, I think, would prejudice our case. We really need to get more into the weeds. I'm learning also a little bit more. I just pulled up a DOD study. I'm not sure. They tested, I think, 12 wells. 5 were above the EPA levels. So we need to get as much as we can and pull as many of our resources as we can, working with our experts locally, so that if we are able to hire an expert, they're able to put forward those kinds of facts. That's what we need.
Could we potentially, however, ask the wrong question that could be used against you?
I probably would refuse to answer a question if you asked me one that I knew would potentially prejudice our case.
Okay.
And I would do it with all due respect, though, so that would make it okay. Yeah.
Sure. My only concern is that we are giving away, a lot of information here. I think we've asked a lot of information. I think we've got pretty much the basics down here. This is a dangerous chemical. We know it's dangerous to mankind. We know that there is an urgency here to pass the bill. So with that, Madam Chair, I move to rise from the Committee of the Whole with a recommendation to certify that an emergency condition exists.
Okay, the motion was made.
Objection, Madam Chair.
Okay,
We
there's
had agreed on going around and asking our questions and then coming back and making our motions on the bill.
Point of order, Madam Chair. There has been a motion right now.
Okay, there's a motion and there's an objection. I'm going to have to call for the vote.
Roll call, please.
So we're going to take the roll call to rise out of the Committee of the Whole. Those in favor? Sorry.
Madam Chair, I object. With all due respect, we have asked a lot of questions and we have received a lot of answers, but we also have allowed some senators 2 rounds of questioning, and not all senators have had that opportunity. And I think we are foregoing a public hearing and we are trying to act on this urgently. It is a huge responsibility on our part, and I can't see if the AG is okay with it. Why are we precluding, just getting whatever further details that we need to make a decision?
Point of order. There's been a motion on the floor that's undebatable. Please move forward.
Madam Chair, may I request a quick recess?
Quick recess,
Yeah.
please. Okay, the Committee of the Whole is now reconvened. There was a motion to rise from the Committee of the Whole. There was an objection and a call for roll call. The members that requested a roll call was Senator Taitigui, Senator Moylan, and Senator Castro. So we would now ask the clerk for roll call. Those in favor of rising of the Committee of the Whole.
Senator Castro. Senator Castro, aye. Senator Lee. Senator Lee, pass. Senator Marsh-Titano. Senator Marsh-Titano, aye. Senator Moylan.
Aye.
Senator Moylan, aye. Speaker Munya-Barnes. Speaker Munya-Barnes, pass. Senator Munya. Senator Munya, aye. Vice Speaker Nelson. Vice Speaker Nelson, pass. Senator Perez.
Nay.
Senator Perez, nay. Senator Rangel.
Aye.
Senator Rangel, aye. Senator San Augustine. Senator San Augustine, aye. Senator Shelton. Senator Shelton, pass. Senator Taitigui.
Ngun.
Senator Taitigui, aye. Senator Pito Terlahi. Senator Pito Terlahi, aye. Senator Therese Terlahi. Senator Therese Terlahi, nay. Senator Torres. Senator Torres, excused. Senator Lee. Senator Lee, nay. Speaker Munya-Barnes. Speaker Munya-Barnes, aye. Vice Speaker Nelson. Vice Speaker Nelson, nay. Senator Shelton. Senator Shelton, nay.
So on the motion to rise from the Committee of the Whole, we have 9 yeas and 5 nays, and 1 excused absence. So I would like to excuse the members of this panel that have come here today, and thank you very much for being here on short notice and for your presentations. We'll recess for a moment.